February 5th, 2026, regular meeting for Emmet County Planning Commission. Roll call on it, please.
Sure. Benjamin? Here. Duding?
Here.
Alexander?
Here.
Bates?
Here.
Edie?
Here.
Neal? Here. Rustic?
Yes.
Willcome?
Here.
Human?
Here.
Thank you, Monica. Okay, this time you join us for pledge of
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, everyone. From us in our packets, we had January 8th, 2026 minutes. Any additional deletions, corrections? Anybody have on the minutes, January 8th, 2026? Entertain a motion?
Second.
All those in favor of the motion as presented, signify by aye.
Aye.
Those opposed, same sign. Thank you. Okay, this time we'll enter in, start the cases this evening, and Laura, you'll be in charge of this. Thank you.
All right. Yeah, this is our one and only public hearing on tonight's agenda for a rezoning request. This is PREZ 2501, Robert Morales for Morales Management LLC. This is to rezone property from FF1 Farm and Forest to B2 General Business. Property is located at 3765 US 31 Highway. It is the east side of US 31 Highway and north of East Brutus Road in section 22 of Maple River Township. Right here you'll see the location maps, identify where the property is, and also an aerial. You can see there's currently a use in a building on the property. The applicant proposes to rezone this property from FF1 to B1 General Business. Property is approximately 10 acres. The surrounding properties are zoned B2 to the west, FF1 to south. There's a PUD that was previously approved to the north and east, and a very small strip of land on the north of the subject parcel, which is zoned RR Recreation Residential. Here is the zoning map, and you can see the outline in yellow is the subject parcel, and noting the red color to the left or to the west is currently B2, and then the surrounding green to the south is additional FF1 property, and then that kind of purple color around to the north and east is where a PUD had been approved. Little background on this parcel. Access to the subject parcel is through the adjacent parcel to the west, and that property is zoned B2 and also owned by the applicant. The subject parcel was approved for a special use permit as a sawmill in 1984. That special, excuse me, that special use permit was amended just this last February 25. So the review process and standards for this proposed rezoning. The Planning Commission has received in their packet the complete application and zoning map, the zoning evaluation. Maple River Township has reviewed and recommended at their board meeting on November 17th of 2025. If you'll recall, this was on the agenda for December. It got postponed to January, and now we're here in February, which is why Maple River did their review back in November. You received in your packet a letter supporting the rezoning from Maple River Township, and that was received, like I said, November 21st of 25. We have not received public comment for this project, this proposal. Review is per Article 27, Administration. Section 27.10 covers amendments, and specifically 27.10.1 is rezoning standards. So that's what the Planning Commission received in their packet, and the zoning evaluation is a review of those standards applying to this proposal. So what I'll do is walk through those standards and what you have in your zoning evaluation in your packet, and before we allow the applicant to add anything if they have something to share, and then of course the Planning Commission can evaluate that together. So the requirement is the Planning Commission shall review and apply these standards and factors into consideration of any rezoning request. The first is the proposed rezoning consistent with the current master plan? And this was noted for discussion by the Planning Commission. The future land use plan map identifies the subject parcel as RR rural residential. I want to remind everyone, these are future land use designations, they don't necessarily align with zoning directly in their use category. That is explained in the master plan. But we do not have a zoning district rural residential, but that is the future land use designation for this property. We also want to point out that it's adjacent to property identified as MU mixed use. And our master plan specifically states that the future land use designations don't necessarily follow parcel boundary lines. And as you can see from this map here, there are kind of loose areas, round spaces that give a general sense of intent for future land use. So that allows for, as it states in the zoning evaluation, some discretion in rezoning reviews and recommendations based on adjacent land uses and approvals would be reasonable here. Next are the allowable uses in the proposed district reasonably consistent with surrounding uses? And it specifically states are all of the allowable uses. Because remember, with the rezoning, you're not rezoning based on a specific proposed use or a proposal. If this rezoning is approved, all of the allowed uses in the B2 zoning district would then be permitted. So that's why we go through the land use comparison charts. This is in the Planning Commissioner zoning evaluation. Understand this is kind of small and difficult to read, but I just wanted to kind of be able to show the audience what the zoning evaluation includes and what the Planning Commissioners will be reviewing. So on this slide, here are residential uses, agricultural, communications, some of the less intensive uses, and the boxes that I just added are highlighting the areas where there is some difference between what is allowed in FF1 and B2. So in FF1, in some cases, something would be allowed but would not be allowed in B2, and vice versa. But if you move now to these land uses that list all the commercial uses and some of the more intensive ones like industrial, this is where we also would want to add those boxes, because here you can see in the commercial categories, the green portion, which is FF1, shows that a lot of these uses are not permitted, not as a use by right or a special land use. But then in the pink column, you can see that a lot of these uses are permitted, which makes sense because this is a request to rezone to a commercial use. So yeah, that's the comparison chart, and that is what the Planning Commission must consider, is all of the potential uses need to be compatible with surrounding uses. Next, will there be an adverse physical impact on surrounding properties? Again, this warrants discussion by the Planning Commission and some consideration. The property to the west, like we've already noted, is zoned B2. Properties to the north and east were zoned PUD. That is an old site plan that was never initiated, and that site plan is not, in effect. But that rezoning did, and that approval for a PUD did take place. Property to the south, again, is zoned FF1. The next category is, have there been changes in land use or other conditions in the immediate area or in the community in general which would justify this rezoning? Again, this would warrant discussion, and the zoning evaluation notes that the property to the east and north, again, was approved for that PUD, and commercial land uses were allowable, including for a campground. Property to the west is currently zoned B2 and is owned by the applicant. The sawmill, which is on the subject parcel, again, was originally approved in 1984, and has been, reconstructed, but the use appears to no longer be in operation. It appears the site is currently being used to assemble pallets and for warehousing activities, but that, again, is not, that's not what's in front of us for consideration, but that is noted in the zoning evaluation because the zoning administrator's been working with the property owner. Next, will rezoning create a deterrent to the improvement or development of adjacent properties in accordance with existing regulations? This is just, I guess, for discussion or for consideration for the planning commission. Will rezoning grant a special privilege to an individual property owner when contrasted with other property owners in the area or the general public? In other words, would this be considered a spot zoning? And this standard appears to be met because the property to the west is zone B2. So an adjacent property is already in that use category, in that zoning district. What is the impact on the ability of the county and other governmental agencies to provide adequate public services and facilities? This is also something for consideration. Those, again, zoning district that is against the roadway is already B2, so that's certainly a factor. Zoning ordinance amendment approved by the planning commission shall not increase any inconsistency that may exist between the zoning ordinance or structures or uses and any airport zoning regulations, airport layout plan, or airport approach plan, and this standard appears to be met. So that is an overview of what you were provided in the packet and what needs to be considered. As I mentioned, however, Mr. Chairman, you want to approach this, but the applicant wants to speak to any of those, or if there are any questions for me.
Yep, before we go to applicant, we got questions for staff? Applicant here this evening. Yes, sir. Anything you'd like to add, sir?
I don't have any comment at this time.
And you're the owner?
I'm Robert.
Robert, okay. For record. Okay. All right, at this time, we'll, public hearing, I'd like to welcome everyone again this evening. There was a agenda sheet and the procedures on the back of it. Please wait for the chair to acknowledge you to speak. Approach the podium, please, we can get, so everyone can hear name, address, and so forth. I think most everyone's been here, consider the planning commission, your neighbors, applicants, and so forth. Try to limit it to, we are going to limit it to 3 minutes per speaking, and if we have other information, we could start another 3 minutes after we've heard everyone. So again, thank you for all being here, and we'll enter in here. Anyone like to speak on this case this evening? Anybody on this case this evening again? All right. Back to the board level for discussion on it, or any questions yet for Laura? I almost said Tammy. Monica. Was there any further discussion, John, since November?
No work. Stands like that. I mean, some of the things brought up appears, number 4 on the response seems to address some of these permitted uses in rezoning tend to be less intense and intrusive than the existing zone. So the township did look at that.
Read your guys' letter out, so that was good. Okay. Thanks, John. Keller, good? Ryan, good?
Yeah, I don't have any questions.
Okay. I don't have anything, I was gonna say what John said there about the intents, and they looked at it, feel approved on everything, so.
Just one other thing that we brought up, you know, the lines don't quite line up. However, the two parcels they own were one parcel. And then the next family split it in two and it was separated, and now they have it back. So yes, this whole thing was one parcel.
Okay,
Other
thank you.
than nothing.
Okay, no further discussion, we'll entertain a motion on this case.
Okay, one
Yeah,
question.
go ahead, Jeff.
Rezoning, that's a two hearing or?
The approval or the steps, the planning commission actions would be approval to the board of commissioners, or recommend approval to the board of commissioners.
Yeah, but rezonings often go to two hearings. But in the past, if it's
Oh.
non-controversial,
Okay,
you simply waive the second hearing, but I'm not sure what the current is.
that is not a current, standard listed, so. It's not, that was how I was bringing this forward. I
Well,
would say, yeah, without.
I mean, there's
adding-
ways to get around
Sure.
it, which we've done.
Mhm. Okay,
Moving on to the planning, or the county
Yeah.
commissioners.
I'm prepared to make a motion.
Okay.
Make a motion to recommend approval of case PREZN 25-01 Robert Morales to rezone tax parcel 24091422400011, section 22 Maple River Township, from FF1 Farm and Forest to B2 General Business, because the standards of Article 27 for rezoning have been met, based on the facts presented in this case, and because Maple River Township recommended approval.
Support.
Support. Discussion on the motion. Monica, roll call please.
Willcome,
Yes.
Alexander,
Yes.
Rustic,
Yep.
Neal. Yes. Benjamin. Yes. Gooding,
Yes.
Eby,
Yes.
Bates,
Yes.
Yearman.
Yes. Okay, thank you, sir.
Thank you.
Okay. Sorry? Yes. Okay, site plan reviews. Laura, please.
next on the agenda is PSPR 25004. This is Letavis Enterprises Incorporated. Request is for site plan review. This is to relocate vacuum stanchions at an existing business known as Fast Eddie's Car Wash and Oil Change, right?
Yes, ma'am.
And located at 1166 North US 31 Highway in Section 33 of Bear Creek Township. Here we have, again, an aerial and location map for the parcel there on the south side of North US 31 Highway. And zooming in a little closer, I want to point out that the aerial and GIS mapping here isn't exactly correct. Everything should be shifted to the west just a little bit on this outline of the parcel boundary. But we do know from the aerial mapping, we also know from their own surveying that they are within the side setback on the west side where those stanchions are currently located. And they were relocated, as we'll talk about in the facts here. Subject parcel is 1.86 acres and is zone B2 general business. Adjacent land uses are the golf course or country club to the west and south. There's a drive-through restaurant to the east, retail across US 31 Highway and to the north. The site is adjacent to residentially zoned parcel. The golf course is, it's a golf course use, but that is residentially zoned. And this requires a 20-foot side yard setback in the B2 district. A portion of the driveway is located over the west lot line. The stanchions currently are located within the required west side yard setback, as I noted. The front yard setback standard is met based on the survey that was provided to the office from October of '24. Little background here, the applicant applied to the zoning board of appeals initially for a 19.1 foot side yard setback, meaning almost no setback from the side yard, and that was to a variance to be able to keep the stanchions in place where they were installed. The zoning board of appeals did not approve that request, but did grant a 10-foot side yard setback variance, and that happened in July of 2025. The ZBA action was conditioned on and required that the stanchions be relocated to meet that approved 10-foot west side setback. And it was conditioned on a screening requirement to be determined by this body. And, obviously that would have to go through site plan review for that amendment to their site plan and in conformance with the ZBA action. This is the site plan that was provided and is in your packet. And this zooms in a little bit more onto you can see the white rectangles are the location of the existing concrete pads where the vacuum stanchions are located currently. And this proposal shows the dashed 10-foot side yard setback line and the relocation of those vacuums to that area. Here we have some photos of the site and the current stanchions. And this is another up-close version showing that there is some landscape rock in that setback area. We understand that the current fence that has some of that vegetation growing in it is on the neighboring parcel, and 3 to 4 feet potentially onto that property. So this is something obviously that needs to be worked out between private property owners, but the need to locate that lot line and provide at least a 10-foot setback when those stanchions are relocated. Okay, in the packet, the Planning Commission has received the complete application and site plan. The fire chief review, noting no issues. A stormwater review was done by office staff and determined that the existing retention has sufficient volume, but should be evaluated for any loss of functionality on that. You received the zoning evaluation, and there has been no public comment on this case that received in advance. So the review process and standards. The purpose is to review the site plan in accordance with the zoning board of appeals action. The township, and I should have taken the township board for Bear Creek Township reviewed this on February 4th, and they accepted the recommendation of the Bear Creek Township Planning Commission to approve this. There were some conditions, and the minutes of the Bear Creek Township Planning Commission meeting were forwarded to the planning commissioners. The review will be conducted according to zoning ordinance standards, Article 11 for the B2 General Business District, Article 19 Schedule of Regulations, Article 20 Plot Plans and Site Plan Review, and Article 22 General Provisions. We noted some items requiring further review and or possible conditions in the zoning evaluation. And that would be compliance, obviously, with district requirements. We're already aware that they're not meeting that 10-foot side yard setback, but that would need to happen. Snow storage is not located, it's not identified on the site plan and is required. Buffers would be required. Right now, no screening is provided on the subject parcel. All of the screening that we saw in those images was on the adjacent parcel. Drainage is the stormwater basin, again, to be evaluated per the stormwater review memo. And lastly, the section 22.04.2, which covers green belts, walls, or fences, notes that a 4-foot to 6-foot tall green belt, fence, or wall is required to provide the screening or obscuring of the parking lot and along that west property line. And in the zoning evaluation, it was recommended that a fence be used, a 6-foot tall privacy fence was the staff recommendation there. Just given the narrow space that there is between the existing fence on the neighboring property and the vegetation that's already existing there, and some of the other ordinance requirements. Our recommendation was that a fence 6 foot tall would achieve the screening that would meet section 22.042, but that is for the planning commission to review and consider. Planning commission might also want to comment on if they agree that a fence is an appropriate way to provide that screening, and if that would be consistent, excuse me, with the ZBA direction. You might want to specify the materials, or if there's any other conditions that you want to apply to that. I think Tom can probably summarize for us what Bear Creek Township's recommendations were, because they recommended approval and all of the conditions that were listed in the zoning evaluation, but some additional as well. So that's all I have, unless there are any questions.
How did this get to the ZBA in the first place?
Yeah, this was initiated through an enforcement action that the stanchions were added without site plan approval, and the office also became aware of some challenges with, between neighbors on encroachments and that sort of thing.
Who installed the existing fence?
The existing fence is on the neighboring property, and that's the country club. It's their fence. The existing fence is within the country club's property,
Right.
and they installed it.
And then who planted the trees right next to the fence?
That would also be,
Yeah, I would assume that.
that would also be the golf course.
Mhm.
And then who put the stones on this side of the fence?
These are probably good questions for the applicant.
Okay. Okay.
Anybody else for staff? We go to
Yeah.
applicant. Applicant, please.
Hello, board members. My name is Jason Murray. I'm the store manager of Fast Eddie's Car Wash and Oil Change. I've been running this location for almost 15 years, and I've been told to assure all you lovely folks that we are going to adhere and abide by any conditions set by this board. We'd like to move forward with these projects and not cause any more problems. So be it.
Questions?
Yeah. Do you know when the fence for the Bayview Country Club was installed?
Before my time. So over 20 years. That fence has been there for a long time.
Do you know when the trees were planted?
Around the same, I'm imagining.
Do you know who put the rocks there?
Yes, Fast Eddie's, we did.
When did you put the rocks there?
2 years ago.
Summer 23, right?
Yes, sir. Tom remembers, he was coming through.
I think I saw it then.
Yeah, we were.
It was red here, I couldn't remember the date was.
Mhm.
And how'd you become aware of this issue?
Of the
vacuum
of the
stanchion,
vacuum encroachment issues, Bear Creek Township was, informed us.
Did you try to resolve this with the neighboring parcel owner before coming to the ZBA?
Yes, sir.
And there was no path forward there, I'm guessing.
I'm gonna say no.
Okay.
Okay, anybody else? Questions? Okay, thanks, Jason. We'll go to the audience next. Anyone in the audience like to speak on this case?
Yeah, Bryon Gutowski, I am the current grounds chair of Petoskey Bayview Country Club, and I don't have an answer on who put the fence in. I mean, I'm sure the country club did. It's roughly 4 feet onto our property. We didn't really know that until the car wash people, they hired Benchmark to do a survey, and we found out that the fence should be 4 feet closer to the car wash. Part of the survey, we found out that 4 of the concrete pads are partially on the country club's property. And now looking at the picture, it looks like those rocks are partially on our property as well. But we attended the Bear Creek Township Planning Commission, and I attended Bear Creek's meeting last night, and we're happy with the proposal that both the Township Planning Commission and the township approved. So other than that, that's all I have to say. Any questions regarding the country club's point of view?
I don't, I mean, I'm not a lawyer, but if it was truly more than 15 years, my understanding is if you installed your own fence and treated it as the property line, my understanding has always been that if that was the acknowledged line, that becomes the line after 15 years in Michigan. So that's why I was curious how now it became an enforcement action when nothing changed in that location. That was just, I mean, this happens a lot with old
We probably
fence
wouldn't
roads.
have been aware of that line
Yeah.
wasn't there. We haven't done a survey on our property. I've been a member for 16 years, and we haven't done a survey to see if the line was there or not.
Right.
But we would have known without this enforcement action.
You would have?
We would not have
Wouldn't
known.
have. That's why I was wondering the genesis of the enforcement action in the first place, right? Like, if the GIS map is incorrect and the country club didn't know.
The GIS, just to clarify if I could.
Yeah.
The GIS map, when you go on the Emmet County GIS map, it says it's for reference only.
Oh, yeah.
It is not that doesn't establish ownership or boundary lines.
I'm not suggesting that at all.
Yeah, and I don't know that what you're offering as far as the law is accurate, and I
Yeah.
would caution against making a determination on ownership based on that understanding.
I led with I'm not a lawyer, and I was really curious about the origin that nothing seems to have changed and then something changed.
Right.
That's what surprises me.
Well, we weren't aware that the concrete pads were put on our property. So.
Right.
And I think enforcement action triggered the survey by Letavis to see where the boundary was, if that answers.
I get it, but that's what I'm saying, like, I
The
understand.
property line, I should say, not boundary.
Right, but I know acutely that the GIS is for reference, and a lot of times this comes up like with hunting on Onyx or things where you see lines and they don't line up with where you thought the line was. I was just trying to understand if the country club didn't know it and the GIS didn't show it, which is for reference, and Fast Eddie's didn't know it, and it took Fast Eddie's hiring a survey to find out, then how could there have been an enforcement action if nobody knew it?
Mr. Chairman, can I just
Yeah.
speak to that too? The vacuum stanchions were not part of the approved site plan from 2018. So they were added to the site plan without that approval process, without an amendment to the site plan. So that was a part of why enforcement action initiated. And then in that process, there was question, does it meet the minimum setback? And then further along in that process, recognizing that the ordinance actually requires 20 feet, not 10 feet. So this is a involved process, and those kinds of questions were addressed at the zoning board of appeals level, where a variance was granted, and all of these considerations were discussed, and like I said, a 10-foot variance was granted with the requirement that the vacuum stanchions be relocated, and the planning commission was then kind of directed to review the screening element and make a determination on that through site plan review. So that's kind of where we are.
So the vacuum stanchions in question, were added in 2018, or the two free ones were in 2018, and the new ones were added in 23? Correct?
Correct.
In
2018 vacuum stanchions were added within the, on the property.
that
As-
site plan,
Yep, but not on the site plan,
in 18 or 23?
2018. And then 5 years later,
Added more, and they weren't put on the site plan, correct?
That answers that, and that's what triggered the enforcement issue, 2023. That permits weren't pulled and so forth, from what I'm gathering, zoning permits and private building electrical, I don't know all that. Does that make sense? Is that what you're?
I understand the words being said to me, but I don't understand this sequence, because the vacuums added in 23 were adjacent to existing vacuums, correct? Did you have any vacuums before 2023?
Yes.
And were
Yes.
they located in this spot?
They were located further up front, the front location that was posted there, on the pictures. They were, the front ones there, the older ones, as you can see, you see the older style that we had right there?
Oh, I'm going the wrong way.
That was,
Where am I going?
Yeah.
Keep going.
Two and they added these, cut this one.
There.
the stanchions that are closest in the photo were there in 2018, and in 2023, the newer stanchions were added. Hence, that, yes, sir.
But in the same line?
Yes, sir, in the same line, but the property line does follow pretty much right there behind those stanchions, several feet over towards the golf course, mind you, but
Right.
yes,
But the front two were there for 5 years.
correct.
Not on the site plan, no permits pulled.
No, the front two were. It's the rest of them that weren't added to the site plan.
They were on the site plan.
The front two were.
And they added the other
So,
5.
so the 2018 site plan had two vacuums on it.
The two stanchions, yes.
Okay.
And those two stanchions are within the setback.
Correct. But that property angle line does go on a taper, and that's where the concern was brought up.
So, I see the front
So,
two
yeah.
with the rectangles,
And the other ones are in line.
and those were on the
They're-
site plan.
Yeah, and apparently, we don't know the history, but apparently those were off, if that's what you're getting at, were off, possibly in the setback in a violation, is that what you're?
Well, right,
is?
but that was an approved site plan in 2018,
For those two,
even if they were in the setback.
apparently,
The minutes from the ZBA indicate that in 1995, they had a site, in 1989, they showed the vacuums on within, 2 feet of the building on the south side, but in 1995, they added on to the building, and no vacuums were shown on the approved site plan at all. And then in 2010, a sign violation was documented and the vacuums appeared. So, and they show up in a photograph, and at that time, there was just the 2 of them. And then in photos from 2010 to 2025, it appears that a couple of the vacuums were relocated in line with the new ones.
So
correct, and I read that too, different parts, and it says in 25 years, they never heard anything that was in violation. This is to the ZBA,
Right.
but apparently they were in violation if you read this whole document. So
Right.
now they're trying to come into compliance, which you understand.
Yeah, I understand.
Right. And the country club's asking to have all those removed, it states in there, those concrete stanchions, because they're gonna relocate them all over to the, we'll call it east,
For compliance, yes.
to meet that 10-foot setback.
And so the conditions that were presented at the Bear Creek Township Planning Commission meeting reference the 6-foot privacy fence installed by the applicant along the property line. So there's a fence that's 4 feet in to the Bayview line, Bayview property, and then trees,
They're gonna put the fence,
like kind of where the rocks meet the concrete, basically.
yeah.
Pretty much.
Yeah, to block more for headlights, and I believe that we're gonna probably look as a vinyl type fencing, and be up to them on color match for the building.
Is Bayview, if you can answer, is Bayview planning to take down the trees and the fence?
I couldn't tell you whether Bayview was.
I actually was looking just
I
past
don't
it,
think
sorry.
so.
We have no current plans right now.
So it'd be a privacy fence, then rocks, then trees, and then a fence.
Yeah, and their fence is just a cyclone fence, wire fence.
Yep, chain link.
Yep. They're putting more for noise and, headlight screening if it were to be in the spring or fall of the year and they're golfing and so forth, along with the screen.
In 25 years, it was never an issue before.
Correct.
So
But it triggered the issue when they did something.
Well, I'm still unclear as to what triggered the enforcement issue.
I agree. And I wanna state too, this is not a reflection on Letavis Enterprise or Fast Eddie's who's doing everything
No.
to accommodate, but I mean, Bayview does a couple night golfs a year, but you wouldn't have headlights when you're playing golf, and there's a huge tree line and an existing fence. I've played that course, I know those holes. I don't think, I'm unclear on what the 6-foot privacy fence is achieving in this situation.
The only thing I can think of would be noise from the vacuums themselves being ran. That's the thing.
I don't think a vinyl fence is gonna do more than a hedgerow.
Fair enough.
But to your point, what triggered, I guess that's
It doesn't make sense.
no. They did something in violation, so someone or staff, I don't know, triggered them to go look at it, right?
Correct.
I guess
So,
I'm gonna be the idiot in the room. Why does it matter? And then the next question is, if Bayview wanted to take that fence down and take those trees down, the privacy fence, the screening is really up to the person that the property owner is. So if we don't say put a fence up and then Bayview decides, oh, my hedges are dying off, then we still need a screen. And then I'm still confused, why do we care what triggered this today? We've got two parties coming together saying, let's make this right. I'm just wondering.
I used to be on the ZBA, I understand TAS, but I know ZBA is sort of the party of last resort in this kind of scenario, so, and then this was brought here to adjust it. I was trying to understand how we got to this position. Just, I'm not suggesting the vacuum should be grandfathered in, it just,
reading some of the ZBA or trying to understand it without doing all the timeline, it sounds like there's been multiple things that have been done not according to
Yeah.
site plan. So this time, someone, whether that be county staff, Bear Creek staff, I have no idea. Electrical permit, we have our own electrical inspector, I don't know that. Building department we have in Bear Creek, as you know, maybe that triggered that.
Yeah.
But they're trying to correct it.
Yeah.
Russ point,
I get
two
the
parties
point that-
together.
You know, what's the big deal now? It's been there for 20 years, but I try to put myself in, let's say, if I own, 20 acres and, for some reason I didn't notice that somebody put stuff on my property, I may wanna exercise my right to say, get it off my property. That's just the way I look at it. Maybe I'd be a good neighbor and just say, it didn't matter to me for the last 25 years, but it may matter if I ever wanted to sell my property, or if I ever wanted to do any future development in that. I think, yeah, I have a concern there.
I'm intrigued with Brian's not a lawyer question earlier. Do we know,
It's
you
not
you
us
said- you
to
said-
review.
Well, you said, you said that wasn't, to be careful about not making legal
Yeah.
references, so, do we know, have legal entities been
It's 15
consulted
years.
on
It's 15 years in Michigan.
this case? Do we know, Lauren?
I really am not comfortable even commenting on that.
No, I just wanna know if.
The legal matter is between two private property owners. We're looking at the zoning. We're looking at a site plan. And we are dealing with, required setbacks. What we know is that the property is residential. Its current use is a golf course. Whether or not it is obtrusive or bothering anyone at the golf course currently is not what we look at with zoning. That could be a residential use in the future. To Brett's very good point, it is not up to the neighboring parcels to provide all of the screening. If I'm pointing out section 22.04.2 requires some screening in this case, some screening is required. Zoning Board of Appeals already heard this case, decision's already been made. They can have a 10-foot setback. And the Planning Commission was tasked with reviewing the site plan and determining what type of screening is appropriate, but that screening must occur on the subject property. So if a 6-foot privacy fence is not the desire of this Planning Commission, you can certainly recommend something else that is consistent with the ordinance provisions. So 4 to 6 tall greenbelt fence or wall. That is what the ordinance states, and that is what I'm suggesting, you work from there. So a hedgerow or some other landscape treatment would be perfectly acceptable. Never do you have to take what the staff suggested.
Okay. Anybody else? Discussion. Kelly?
The only thing I find, and I realize it's speculation, if, for whatever reason, that would have been on the original site plan, would we have let it go through? Would there have been reason? Cause? If we.
It would have been encroachment into the setback.
Well, yes, outside of that, we probably would have maybe worked with them and maybe relocated a bit more. But if it, and it does seem they're trying to correct the situation, it's kind of a no harm, no foul. Yes, it wasn't done the way we would have liked it to be done, but at least the situation is being resolved.
That's correct. ZBA ruled on that in this direction. Okay. We've already been to the audience, right?
Mhm.
Get back here. Bryon talking. Okay, I perceive the, you know, what was discussed at Bear Creek Township Planning Commission and, Township Board last time, we just went on the recommendation. But they suggested privacy fence, but we could do intensive screening, evergreen screening, 6 foot tall, or privacy fence. I think Mr. Jason Letavis are willing to work whatever we suggest. I think the country club would like one or the other. They did require those concrete where the stanchions were to be removed. You guys are aware of that. They're agreeing to do that, so that's kind of what's in front of us. They're gonna correct the encroachment. They granted them 10 foot rather than 20 with that fence, and the country club is gonna keep their existing fence and tree line, and then Letavis is gonna, I think that's the understanding.
Do you know if Letavis has a preference on if it's a 4 to 6 foot tall green belt fence or wall?
They are willing to adhere to any requirements they'll do vinyl fencing, they'll do 6 foot tall, they'll do 4 foot tall. I was informed they do a wood one if that was necessary. We would like to, try to have a little bit of color scheme matching going on for the company. I mean, if that's within reason, of course.
Are you open to a green belt, like not a fence, but trees, vegetation?
Rocks, we kind of like the rock look, keep the tree maintenance down and stuff like that. So not gonna really want to add any more shrubbery.
Okay.
If required to move some of them rocks, so be it. We already did agree to say, go ahead and move the stanchions and all that, get to tear those up and take care of that stuff. But as far as the fencing, they're willing to adhere to whatever the board sets for us.
So I'm hearing that you would rather have a fence as opposed to shrubs or trees.
Yeah,
Is that what I'm hearing?
That's what they told me, yes, sir. The owners,
Monica, could you go back to those?
the owners did say that they would, be more than happy to put up a privacy fence, that would, help with noise reduction for the golf course. They're golfers, avid golfers too, they're trying to have some understanding of that whole situation too. The only thing they ask is, to leave a little wiggle room for color match kind of scheme going on, other than that.
The fencing will be about where those stanchions are now, because the stanchions are gonna move to the east. And then those concrete pads are gonna come out of there.
Correct.
Okay, that was my question. It's not proposed on the property line, it's proposed on the setback line or
Correct.
somewhere in
Correct.
between?
And that was another, requirement, so when they do either plant or plant trees or plant posts for the, fencing, screening, let's call it, either or, that they will have a benchmark or whoever they hire.
Correct, we're gonna
Shoot 'em
pre-mark
lines so
everything
that-
out
To
before.
make sure they're 10 feet or more,
Yeah.
and not encroachment again.
Kind of like a mock-up, we're gonna put marks down, we're gonna mock everything up before we erect anything to make sure that it's okay.
And that was in the motion, Berkeley, that they would provide that line, and that staff could go out there and look at, yep, they're 11 feet in,
Correct.
or 12, or whatever.
Do you know where, I know snow storage is not on the site plan, do you know where that's gonna be proposed?
We push that all the way in the back,
Just to the right of the pond?
all the way in the back. No, we don't even actually push it into the pond. I mean, obviously some of it
Yeah.
does get pushed, but, no, all the way into the back, on the back parcel of the property. It sits right there. Right now I got 9
A
foot
lot,
tall.
yeah, right.
And they do push it to that. And what the other requirement was to have the drainage pond, evaluated to see it needs to be dredged now.
It was dredged. I do know that it was dredged when the McDonald's went in when the McDonald's had their part of the pond redone, and so they can expand and hold more, the retaining pond. They did dredge it when that was done. when they did,
Said somewhere in here that it was oversized for the site when it was replaced.
Right.
Yeah.
It was. But they just wanna double check and make sure.
Yeah, and they said that, the owner said that they would be more than happy to have somebody come out and assess that for us.
Perfect. Okay. Any other questions for applicant or staff here? I entertain a motion. Anyone would like to offer one up? All right, here. Back page of that. Zone evaluation packet. So next, I know it's kinda.
This one?
Yeah, yes, sir. Yeah, they're all kinda. Last page. Yeah.
So that was in
All the
meetings.
way to the back. You got it. Keep going. Right there. Yep. It's all good. You were gonna offer a motion? Or you're reading?
I'm reading it right now.
Okay, all right.
If anybody
Any
else
other
wanna go?
discussion, or?
The only question, I don't wanna push this as far as more time, but if we put up a privacy fence, maybe this is what Bryon was getting into, is we have a fence, we have another fence and shrubs, there's an area in between there, could get pretty trashy, how do we address that? And is that our purview to do?
I think it's gonna be a wind trap for crap.
So,
I'm starting to see, I understand your point, but.
or if you go back to those pictures, Laura, please. So if those 8 are gonna be moved to the east, 6, 8 feet, I guess it is 10. So yeah, we'll have a double row, they could extend the rocks there and put some, I know they didn't like the idea of lower shrubbery, but possibly another stack of shrubbery there, 4 to 6 foot.
They
tall.
feel that, they would be more than willing, I know the Letavis would be more than willing to even fill that in with more landscaping, and because we maintain that, pick up the trash, we pick up that fence line anyway, as it is. Now, if we were able to just extend the rocks out a little with extensions and just put the landscaping there, then it wouldn't be an issue. We would still maintain cleaning it and weed whipping, and
That's not your property.
Yeah, you don't have to anymore.
but it's facing my building. I like my stuff to look
I
nice.
get it.
And it's on my side, it's on this side of the fence anyway, so it doesn't hurt my feelings to maintain and to keep that stuff looking nice for both of our benefits.
What I'm talking about is between your fence and them shrubberies, and that, the rocks are on the Bayview, the country club's property now, so that property is actually the country club's property to maintain. Am I
Yeah.
looking at that wrong?
No, you're right.
That'd be the golf course's responsibility going forward.
Understood. At this point, it'd be up to the board whether or not they want a fence. We can work out the details with the golf course, I'm sure, on property maintenance.
And I'm still struggling with the fact that our zoning says we have to have a fence. I just wanna make sure
We have to have 4 to 6 foot green belt, fence or wall. We don't have to have a fence. We don't have to have a green belt. Could be a concrete wall, retaining wall, formed wall. I mean, but whatever it is in the present form is gonna go downhill from a rock slope, from trees and another fence within 8 to 10 feet of each other.
From that existing hedge.
Yeah, I mean, obviously it's on a, as
Yep.
is so commonly the case in these property line issues, it's on a taper, right?
Which was, I'm assuming dug back a little bit to put those stanchions there, I don't know that for sure, but. Make a motion that they would, I don't know, just, work with some sort of screening with Bayview Country Club would be appropriate or something.
I
so.
cannot, in good conscience, support a motion where they're meant to cooperate when they already had a chance to cooperate and we're here solving it for them.
Okay, then we need to solve it.
I agree.
Well, I guess the option is we do what the zoning ordinance says, we put the fence up, and then when it becomes, if it becomes trashy, then it have to be addressed with the owner of the property.
The owner of the property on which the trash is located.
Right.
Correct.
Which is big.
That's correct.
You got anybody in here?
I think, yeah, if you're asking me what, how we weigh in, is exactly what was provided in the zoning evaluation. That, Letavis property has, a responsibility to provide screening for their own use. Recognizing that, there is not a lot of space there. A privacy fence was thought of for that exact reasons that Bryon brought up. That if, and this would be something that the property owners could potentially work out, that they keep the rocks there and they put a skinny privacy fence up and easier to maintain between the hedgerow and the fence. That does not, that's all, I guess that's all I can offer, because I feel like that, that was exactly the considerations that staff had when we were on site and looking at pictures and deciding how to achieve this when you only have maybe 3 to 4 feet on the country club side, and then you would have 10 feet till you get to the stanchions. That fence can be right on the property line. It doesn't, there's nothing that says they couldn't put their fence on the property line, and then there's nothing that would say that Bayview Country Club couldn't remove their fence if they wanted to, that is 3 or 4 feet onto their property. So how that maintenance goes on in the future and who decides to keep what shrubs, I guess is beyond the discussion I anticipate that the planning commission would be getting into this evening. So,
So,
yeah.
to interrupt you just a little bit, we do have the ability to put the type of fence, and I think that's what you were getting to. Are you trying to get to the fact that the green border would be better for maintenance that? I don't know if it would.
I think the right solution and the realistic solution are not the same solution. Okay. And I mean, I say it all the time, pretty big property rights guy. I think the solution as presented is going to unfairly impact the property rights of Letavis Enterprises. I can't think of a time where we would approve a site plan with that steep of a slope from somebody's property onto an impervious surface on an adjacent party's property. I think a retaining wall would be a better solution, but I'm not sure that a retaining wall is a financial burden that Letavis should have to undertake to solve this grade. The grade is not on Letavis's property. So I think a fence is gonna get mangled and collect debris, and I think when those stones roll down, it's gonna be on somebody else's property. The only way to fully stop that, I don't think shrubs would stop. I think shrubs would look better, but I think the ideal solution would be a retaining wall with shrubs on top. but that's the most expensive solution, and I don't think that that's a problem that was created by Letavis. And so ZBA they did their job, this is our job, but I know when I was on ZBA, it's the question is it self-created? And it's the solution here, I don't,
But to the slope, we don't know if that was self-created or that was existing. But there is stone on there now, so whether that was excavated out to put those stanchions in there?
yeah, we don't know.
that, so,
Yeah.
so do we require, I mean, we could say,
But we can't require Letavis to remove stones on the other person's
not
property.
now, no, I agree. That's up to their, so the task at hand was screening.
Yeah.
Okay. 6-foot evergreens, 6-foot fencing of some material, I guess is what we're at.
Or
John, you
six-
wanna weigh in on anything?
I think the fence would be the proper thing, and I'm not sure that we really have to specify too much on it, because I trust the applicant's words that they're going to do what's best for the business as far as color, et cetera. At this point, I just think fence,
And
what
maintain.
their zone calls for, and let them figure out exactly what their fence is and what.
They do keep it a nice place there.
They do.
It's maintained very well. Okay, entertain motion? We wanna make a motion in
Mr. Chair, I'll attempt a motion here. I make a motion to approve case PSPR 25-004 Letavis Enterprise Incorporated to relocate 8 existing vacuum stanchions to adhere to a variance approved by the zoning board of appeals for a 10-foot west side yard setback at 1166 North US 31 Highway, Section 33, Bear Creek Township, tax parcel 2401633200019, as shown on the site plan dated received December 29th, 2025, because the standards of Articles 11, 20, and 22 have been met. And based on acceptance of the facts presented in the staff report dated January 19, 2026, and during the site plan review, and because Bear Creek Township recommended, is that true, approval?
Approval.
And do we need to add the conditions, and, yeah, and further, that the approval is conditioned on the following: any fire department stipulations shall be met. Applicant shall install a 6-foot privacy fence along the west side of the property line to screen the vacuum stanchions area from residentially zoned properties to the west. Applicant to provide an updated site plan identifying snow storage locations and required privacy fence prior to the issuance of a zoning permit. And the stormwater basin needs to be evaluated to determine capacity. I think that's all I've got.
Two, just quick comments. One, in the written motion, Letavis is spelled incorrectly, and to LE, and then for the tax parcel number 240116. Just missed a 1 in there.
I missed the one?
Yeah.
Okay, can we amend that to properly spelling the word Letavis and tax parcel 241633200019?
With those corrections, I second.
Can I add a condition? That was in there, those existing concrete pads would be removed out of that setback. That was something that the country club requested, and the planning commission and Bear Creek Township both made that motion. So on the site plan, it says remove existing equipment from existing concrete pads. Existing pads to remain in place. Those existing pads need to be removed. So on the site plan, make that correction.
So the
if that's okay with you guys.
Can we add that? Alright, so with that correction,
Support. Any other discussion on the motion?
Did you also, Tom, want to mention I know that Letavis has already indicated they are going to do this and are willing to do this, but the marking of
That
the
boundary
setback,
survey.
yeah, just mark the property line and the setback line prior to construction. That's something you wanted to add?
so further adding that the Letavis have the property line professionally marked. That would-
Is that for the sake of construction or in perpetuity?
The setback.
Just prior to construction.
And the setback line.
And the setback line prior to some permit for construction. So can we add all that?
You can,
Is that, are we good there?
we are good.
Okay, any other, wait a minute, I'm not running.
No, you're good. No, you're good. Anybody else?
We're good.
Support, second, still good?
Not to cause issues, but you do have two other sort of conditions on Bear Creek Township minutes.
Go ahead.
The length of the fence to run from the front back extension to the corner of the building, and the scale on the site plan be corrected. Those were in the Bear Creek Township motion, so I'm not sure if you want to include those or not.
And I thought about that, but it was kind of stated where it ended the stanchions on the fencing, but if we wanna go to that
That's up to you.
corner.
Just telling you what's here.
so They wanted to go right to this would be the northwest corner.
So do I need, can you add the word?
I've got that in here if you wanna just,
So
it would be,
the motion should also include the stipulations from the Bear Creek Township.
so the only ones you did not say were the, adding the length of the fence, runs from front back extension to the corner of the building, and the scale on the site plan needs to be correct.
Yes, that's what I wanted
Okay,
to say.
that's what I thought you said.
Still got it.
Still good, John?
I was just gonna have you promise to do it. I'll go with a second.
Okay, roll call,
All
please.
right, Herzig,
No.
Bates,
No.
Alexander,
Yes.
Benjamin. Yes. Neal,
Yes.
Lothbaum,
Yes.
Minimal's Gooding,
Let me think. Yes.
and Herman.
Yes.
What about Evie?
Oh,
Yeah.
you get to vote now,
I
Chief.
second.
Evie? You second, and you vote? That's a yes, though, I assume. Okay.
Okay, thank you. First and paperwork here.
Jason? No, we'll be in touch.
Okay. Next case this evening. Laura,
Okay.
everybody good? Paperwork shuffle around?
All right, the next case is PSPR 25005, Bryon and Willcome. This is also for site plan review. The request is for forest production operation, log storage yard and related at 5722 Rustic Road, section 36 in Bear Creek Township. Here is the location map, right here on Rustic Road where it bends, and just kind of north of Bristol Road breaks off. Up close of the property, and this area was before any activity began on the property. Quick summary, the subject parcel is 10 acres by definition, zoned FF1 Farm and Forest. Surrounding parcels currently are residential uses and are zoned FF1 to the north, west, and south, FF2 to the east across Rustic Road. Proposed use is forest production operations, log storage yard, and related. Also to allow 2 metal storage containers and shed to remain on the property, and a future pole barn is proposed. Hours of operation are proposed at 7 a.m. to 6 p.m. Monday to Friday, and occasional work on Saturday and Sunday was noted in the application. And it would be this again was described in the application, delivery of logs to the site 3 to 4 times per week. log storage, processing logs for firewood, dump truck delivery of firewood 3 to 4 times per day, and starting and finishing location for 3 to 4 employees. Background on this case is it started as an enforcement case initiated on August 29th, 2025, when the Planning and Zoning Office became aware of a commercial use of the property. Owners were provided options for bringing the property into compliance. The owners applied for a special land use and site plan review to operate a contractor's use. As this board knows, this body knows, the case was denied by the Planning Commission on November 5th, 2025. Following the special use permit denial, the owners notified the Planning and Zoning staff that their tree service business would no longer operate out of the Rustic Road site, and they submitted a new application that is before you now for site plan review, identifying, as I've mentioned, forest production operations, log storage yards as the intended principal use. Here is the site plan. It's in your packet. We have some photos that were taken earlier in the year. You can see the, from the road into the area where the operation occurs, and it's the location of the storage container and log storage in the distance. We provided with this case a use analysis, and the reason for that is this use is already underway, as we know. Became aware of the commercial operation in August, and the applicants were in front of this body for a contractor use. There was discussion about Forest Products Processing Limited with the applicant, and when the site plan came in on December 30th, it was the same site plan that we received previously, and this time noting forest production operations and log storage yards and related as the principal use. So this has been, I will just say it's been a bit of a struggle, trying to work through what is already occurring and looking at where that fits, if at all, you know, what type of a use designation it would fall under. And I hope this body understands that the Planning and Zoning Office staff really try to work towards compliance and try to follow very, you know, very religiously, I guess, very cautiously the zoning ordinance version. So this is where we are. Believe that it was very important to provide a use analysis given the challenges before us, and to fully understand what's actually happening, what's being proposed, and how that fits in the ordinance. So we looked at zoning ordinance article 18 lists forest products processing limited, and that limited notation is there, along with forest production operations, log storage yards and related, as a permitted use by right in FF1, FF2, and FR zoning districts. Again, in the application, the project description lists 10-acre parcel being used for forest production operations, log storage yard and related, 2 metal storage containers and a small shed are currently on the site. We propose the addition of a pole building in the future. Although forest products processing limited is part of this use category in the land use matrix, the applicants did not include that. That activity in this request. The use currently occurring on the site and that is the subject of this request involves logs being hauled to the property, cut into firewood, and then distributed off-site. So what is included in that use category? This is what staff had to look at in understanding really what the zoning ordinance provisions are. So forest products processing, there is a definition for forest products processing in the ordinance. Again, in the land use matrix, it adds limited to the allowed use by right in FF1 and FF2. But the definition in Article 2 for forest products processing is defined as harvesting operations of trees, tree forms, including portable sawmills, log storage yards and related, Examples of these products include pulpwood, cordwood, lumber, and like products, the sawing of logs into lumber, or the conversion of logs into ties, posts, pallets, and similar products. Limited, again, is included with forest products processing in the land use matrix, but that limited element is not defined, and there aren't supplemental regulations for this use, so we don't have that clarification either. Forest production and log storage are not defined in the zoning ordinance. Other terms and words within forest products processing definition are also not defined, such as harvesting. So how do we determine, we don't have every possible definition in the zoning ordinance. And what we do know is Article 2 is very specific. Any word, this is provision I, and this is a screen capture of Article 2 from our zoning ordinance that is available on the website. Any word or term not defined shall be assumed to have the meaning customarily assigned them. And provision K states any necessary interpretation of this ordinance shall be made by the zoning administrator. So that is set forth in Article 2 prior to the definitions being laid out, that it's the zoning administrator who would make any necessary interpretations, and if there is a term or word that defined is not defined, then what is customarily assigned to that term would prevail. So there is some interpretation required here, and that's what is done in the zoning evaluation. And everything that I'm going to now go through, understand it was done because that is assigned to, and it is the responsibility of the zoning administrator to interpret the zoning ordinance and specifically to look at these definitions. So continuing with the use analysis, we looked at forest products processing limited. Again, I've already read what that is defined as: harvesting operations of trees, tree forms, including portable sawmills, log storage yards and related, and then it goes into a listing of products that could result from this processing. Harvesting is, again, not defined in the ordinance, but it was the interpretation of the zoning administrator that harvesting customarily means the gathering of crops. If that is then a principal use on the property, it would assume that the crops are located on the property, if that's the principal use occurring on the property. And not to be brought in, the harvesting brought in somewhere else to then process on a different location. We also noted that portable sawmills is referenced in the forest products processing definition. So the idea to reference a portable sawmill in the definition would imply temporary or non-permanent processing operations if you have a portable sawmill. And that, again, the interpretation was that that is different than a principal use, which would then be looking at something like a sawmill where you have a structure and equipment that are permanent. So that led to the idea that looking at limited in the definitions and in that use category for forest products processing. So what is limited? And we looked to the supplemental regulations for sawmills, which I want to note that is not what is being requested here, but it is a special land use in industrial FF1, FF2 districts, and it is subject to supplemental regulations. But by looking at how does the zoning ordinance treat sawmills as a use compared to forest products processing, which is a use by right, it is enlightening, put it that way. So this is, again, an excerpt of the zoning ordinance, screen capture. This is section 26.22, sawmills, planing mills, veneer mills, and accessory or incidental mill operations involving logs, unprocessed timber, and or sawn lumber. So it is similar, but this is specific to these sawmills. Provision G, just bring your attention to that. There are some provisions here that I won't get into, but this also very specifically details what are the requirements for setbacks property size and so on, if that is what is going to be pursued. But provision G says nothing in this ordinance shall be interpreted to exclude temporary and itinerant sawmill operations on FF zone property where the timber harvesting involves only those resources found on the same property. No permit shall be required where the operation involves a period of less than 6 months on the same property or zoning lot. That is specifically mentioned, and we believe provides some insight to what limited might mean, or what the kind of alternative to a sawmill as a principal use and a permanent structure and operation on a parcel. Moving on, forest production operations, again, that is not specifically defined in Article 2. But looking at forest production and the general understanding of what forestry and forest production customarily means, the zoning administrator believes that is the management and harvesting of trees. Again, as requested as a principal use in this request, it would seem, and we would assume that forest is on the property where that operation is happening. Now, we understand that you can always have trees cut and logged and removed, and that doesn't require site plan review. But if you are then producing products and sawing and creating some kind of a product that you then process on the site beyond just the harvesting and removal of trees, that gets into something else that does require site plan review. And then it might be a temporary itinerant situation or a long-term and permanent situation. And our review of the ordinance provisions and the comparisons of these other uses has led to these interpretations that I'm now summarizing for you. Lastly, log storage yards. There is not a specific definition for log storage yard, but we do see in the definition for outdoor storage what would apply here, defined in the zoning ordinance as a land area occupied and used for open storage of products, building materials, sand, gravel, stone, lumber, equipment, and other supplies. So we have some similar definitions that we can look to and understand how to apply that. So wood harvesting and forest production as forestry operations, we believe is consistent with other agricultural uses that are permitted by right in the farm and forest districts. Completely understand and agree that forestry and harvesting makes sense and is consistent with the use by right in those districts. The zoning administrator and staff, though, find that the use occurring on the subject property does not fit forest products processing, limited forest production operations, log storage yards, and related. Understand that it does use logs, but beyond that, we find there is a disconnect. So we don't believe that it is consistent with other harvesting and agricultural uses permitted by right in the farm and forest districts. And for these reasons, the applicant is initially guided to pursue a special land use for contractors' use. Also determined at that time that the property would not be fitting or qualify for a sawmill operation because of its limited size and because of its proximity to residential uses. A moment ago when I showed you those provisions, it doesn't meet the 1,000-foot setback to a residence or 500 feet to log storage. So we do struggle with these things. When we put together a zoning evaluation and offer some insight, background, and make a recommendation, it is based on a lot of time spent, as I said, struggling, looking through this, and spending a lot of time with the ordinance. So that is the use analysis that we are offering. Planning Commission, in just a moment, I'm gonna kind of lay out what, where we go from here. But the review process and standards I want to cover quickly. The Planning Commission has received in their packet the complete application and site plan. packet, the fire chief review. Fire chief's requiring an address sign at the road. And the county road commission review requires the driveway to meet commercial standards. You received the zoning evaluation, and like all zoning evaluations, we lay out all of the provisions that apply and end with, a summary of the items that, require or we believe need additional discussion. We received public comment in advance of the meeting. This is not a special use permit, so this isn't necessarily a public hearing, but we have received comments from the public, from Amanda Dow, Matthew Dow, Maria and Adam Yeager. Those were all in opposition. On your desk tonight is an email from Vicki Vance. This was just received today. This is also stating opposition. And you received, a couple days ago, another, email. It came from Amanda Dow, but it was, listed by Joshua Ross, also in opposition. We also have received 2 letters, and the planning commission received those, from Andrew Blodgett. It's the attorney representing the applicants. This was supporting the Willcome site plan review and commenting on the use and the zoning evaluation of staff review. So this is what we've received so far and what you have received. The purpose is to review the proposal, and the site plan. We agree that if you determine that, you're moving forward to review the site plan. The township board, at Bear Creek Township and their planning commission already conducted their review. Last night, February 4th, was the township board review. They made, a recommendation to Emmet County Planning Commission, consistent with what their planning commission review was, and that was a recommendation for denial. That was based on, acceptance of the zoning evaluation and the zoning administrator's interpretation of the use. But for you, the review would be conducted according to zoning ordinance standards for Article 8, Farm and Forest Districts, Article 19, the Schedule of Regulations, Article 20, Plot Plans and Site Plan Review, and Article 22, General Provisions. Again, this is the site plan. As far as items requiring further review and possible conditions, I will just highlight those briefly. First off is the proposed use. Obviously, we're caught in a difficult situation if we find that for what is listed as the use and what is occurring on the property does not, in the zoning administrator's assessment, align properly. So we would first ask, under proposed use, does the planning commission have any questions or comments on that analysis? Possibilities could be to accept the interpretation of the zoning administrator, support different findings based on the zoning ordinance, and I wanna stress that, this can't be arbitrary if the planning commission, believes that there is something else in the zoning ordinance that provides a different, understanding, that fits that use category, then, that should be cited specifically and referenced so that any decision is not just arbitrary. And lastly, another option would be to postpone so the applicant can obtain a formal interpretation from the ZBA. That option, I just want to point out, was offered to the applicant, and a ZBA application packet was sent, I believe, on January 21st, as something to consider. So that's where we are for this evening. If you move on to site plan review, your zoning evaluation also listed items for consideration there. There are some questions about walkways, loading and unloading areas, which face or are visible from residential districts, are they sufficiently screened? Are there reasonable visual and sound buffers provided, or should additional techniques like we just discussed with screening, fences, walls, green belts, and landscaping be required as a condition of approval? Stormwater management was not provided or addressed, and the planning commission would have to determine if that would be, waived or not. And then lastly, no enclosure for the, waste receptacle was proposed, and they were looking for, that to be waived as well, because they believe the existing natural screening meets the intent. So that is a big overview of everything to unpack with this, and review. So I would, ask if there are any questions for staff on the review. Hopefully it's clear that a lot of time was spent trying to, work towards compliance and an understanding of the zoning ordinance provisions, but I'm happy to take any questions.
Thank you, Laura.
Mm-hmm.
The guy?
Yes, this was a lot.
Where's Jennifer? I'm sorry.
Few questions. Regarding the Bear Creek Township, minutes, I see that it was ultimately motion to deny. So backing up with that, did you go through this same approval process with them in talking about the use?
At the Bear Creek Township Planning Commission meeting, of which you have the minutes, yes. I was
Okay.
there in attendance, staff always presents at Bear Creek, and they did, yes, receive the same summary that is shown in the minutes.
So what was their review? I guess I'm not seeing it in the minutes in terms of this part of it, of the use.
Of this part of it, of the proposed use, they determined that they, accepted the zoning administrator's, analysis and interpretation, and recognized that, the zoning administrator is tasked with that. There was a mention of the zoning board of appeals being the body that, would do that, but I think for Bear Creek Township Planning Commission as a recommending body, did not get into, a further deep dive into, questioning or challenging the zoning administrator's interpretation.
Okay, so they talked about the ZBA, but didn't recommend doing that,
No.
essentially, okay,
They didn't really talk about the case,
yeah,
like they didn't open it, so to speak, they didn't sort of advance.
yeah.
They determined that, as Laura stated, that's where they were gonna go with it, and so they did not go into site plan review.
Oh,
Is that where you're
Thank you
going?
for- okay.
They just decided that decision to know that it was not allowable use.
Use.
And so
Therefore, the
their
site plan.
discussion, they decided that, in their discussion, that they weren't gonna go any further. I was just an attendance listening. And that's where they decided they entertained a motion to go no further, and then so they did not review it. It's like,
Okay, that's a little bit confusing in the minutes because it says motion by Seibert to deny case,
Yeah,
for
It's-
site plan review.
it reads like a denial
Right.
after deliberation, but it didn't advance to the stage of discussing, comment, etc.
Okay, thank you for clarifying. I guess
but
that's all I have.
Jennifer, Brandon? Any else? Discussion? John?
I think,
Okay, you good or?
Yeah.
You got something?
no, good.
Go ahead, Scott.
I maybe have a question. Trying to think how to frame this correctly. So we're talking about moving forward, we're talking about whether we accept the evaluation of the zoning administrator. And you mentioned a minute ago, Laura, that if we don't, to cite specific things in the ordinance. What if those items that we would cite are the exact same items that the zoning administrator cited, but we have a different interpretation? And I recognize that the word interpretation is a loaded word in this particular case, but what happens in that case?
I think,
Were you asking me to answer that?
Yeah, but or whoever might have a good answer on that.
Yeah, as long as it is tied back to the zoning ordinance and supported and justified, that's what you would need to do. It would not just be, we think it fits. That's all I'm offering.
Okay.
Is that you'd want to be specific, in that determination.
I just wanted, yeah, in reading the Bear Creek minutes. They jumped pretty quick to a decision of not moving any farther forward.
I think I'll offer, it was very, in my view, similar to how the contractor use discussion went, where it was first, does it qualify as a special use permit, for the special use? Because to go into the details and nitty-gritty of what is required of a site plan did not seem to make sense if they didn't feel that they first qualified or could be approved for the special use. So, having, sat through both of those meetings, I would say they were kind of drawing that parallel, and that was even asked, by 2 members of the planning commission. So,
I get that.
if the use doesn't fit, do we move on to review the site plan?
I don't think that I personally agree with their evaluation of that.
I would agree.
I think perhaps,
And I would cite Article 8 and Article 2 as the specific instances of where this would be a use by right, and there's language in the ordinance cited in the evaluation that supports this use by right. Definition, oops, pardon me. Definition provided in Article 2 and Article 18. It's the harvesting operations of trees, tree forms, including portable sawmills, log storage yards, and related. Examples of these products include pulpwood, cordwood, lumber, and like products, the sawing of logs into lumber, or the conversion of logs into ties, posts, pallets, and similar products. That is the only definition provided in the ordinance for this use. That definition describes exactly what they're requesting to do on this parcel. They are not requesting to build a sawmill according to Article 26.22. They are not requesting to do those more intensive uses. I understand that the definitions in Article 2 say if it's not defined, we need to use the normal meaning. I think the good news is it is defined, and their application is the definition of what's permitted use by right. I think hearing the site plan review would be fair to the applicant and in line with the ordinance.
I would tend to agree.
Anybody else? Give me those again, Bryon, all those articles you just, I got some.
Article 2, 8, and 18.
That's what I thought.
The definition is in Article 18. The land use district is Article 8. It's a use by right.
Definition is Article 2. 18 is the land use matrix.
Right.
Eight's your farm forest, right?
Yeah, correct. In the zoning evaluation, it cites zoning ordinance, Article 18 lists forest products processing, limited forest production operations, log storage yards are related as permitted by right in the FF1, FF2, and FR zoning districts. In Article 8, it lists the uses in the FF1 and FF2 farm forest districts, and the definition referred to in both land use matrix references is in Article 2, which includes the statement, examples of these products include pulpwood, cordwood, lumber, and like products. That is what the applicant is asking to do. If it was exclusively harvesting, they would not need a site plan review or to be before this body. So I can't imagine that the definition provided, that's specifically why it shows the attributed uses.
Okay.
I think from a site plan standpoint, I'd be comfortable waiving the stormwater management and the requirement for a receptacle enclosure. I don't think you need walkways to the entrances, but I do think in the point D and point F for screening and buffers, I think a berm on the north and northwest where the trees don't exist, I think a berm would be an appropriate sound buffer to protect that use and any visual or sound generation. But I think a berm would be more effective in this case than vegetation for dampening the sound.
So we haven't gone to applicant yet for the public, just state some concerns.
Yeah, I think a berm should be front and center in the conversation of how to make this fit. The parcel's large enough, the uses, setbacks are fine, but I still think a berm would be a good faith effort to provide the screening as cited in the site plan review.
I just have one quick question.
Angela?
So in the definition in Article 2, then the whole harvesting portion of it is that the zoning administrator indicates that, harvesting the crop comes from the land that you're harvesting from. So that entire portion of it, you're saying, because they're doing all the other things, we don't need to pay any attention to the harvesting.
Well, I'm not saying we don't need to pay attention to harvesting, but I'm saying that the applicant doesn't need to request permission to harvest. Like, you could timber 1,000 acres and not come before this body. So I think the definition we have is for forest products processing limited. The evaluation says harvesting by definition means, but that definition is under the premise of not defined equals normal meaning. That's not something our ordinance is calling out. It's in there that harvesting operations of trees, tree forms, including portable sawmills, log storage yards, and related. Examples of these products include pulpwood, cordwood, lumber, and like products, the sawing of logs into lumber, the conversion of logs into ties, posts, pallets, and similar products. So I think, to me, Article 2 is a coloring in the lines to give a sense of what forest products processing means. And I don't really want to go make leaps beyond that, but I think, they're trying to draw a distinction and you're working with raw materials and turning it into something rather than, say, the delivery of 2x4s on a, bunk trailer and then building something out of that.
what's, anybody else got anything? We'll go to the applicants. John, anything that right now? You're thinking,
I've got things to say.
applicant like to address this evening?
Hello, I'm Hwy Willcome and this is Bryon. We're the ones who put in the application. And we are here speaking before you tonight in hopes that you will be willing to listen with an open mind to this case that is before you. Despite the fact, as you know, that our motion was denied before the planning committee and the township board last night, we hope that despite that you would be willing to look at this with an open mind. I can answer your questions. Many of you asked questions about what happened at that first planning committee meeting. And what really happened was, once she explained her use and they started to discuss whether this was the correct use or not, or have any chance to think about it themselves, they asked the zoning staff member if they were able to discuss this assessment of hers. And I quote this from the video that I wrote this down. The response that put an end to the discussion was that the planning committee, the zoning staff said, the planning committee has no authority and it is not their role to make a judgment about this determination. And the thing that makes me upset about her saying that at the meeting is, I did specifically call and talk to staff about this exact question. And when I asked, that statement was never told to me. They said you could go to the zoning or to the Board of Appeals first, or you can keep going to these meetings. They never told me specifically that this board had no authority and it was not their role to make a judgment about the determination. But yes, she said that publicly, but when I asked and called, that was never told to me. So that really wasn't right. So we're still here to argue because we were not told that before the meeting, before we went forward with these meetings. And our lawyer had said that, you know, there really wasn't a determination made yet. There was no judgment. So what were we really appealing? That we still could go and discuss and ask you guys to think about what really makes sense for this. We're asking you to be willing to listen to our reasoning about why we think we do fit this use that we applied for. Forest production operations, log storage, and related. And first, we just would like to acknowledge that no one is perfect. We all make wrong decisions at times. A mistake of ours was misunderstanding the zoning ordinance when it said that this category, we just call it forestry production, is permitted by right. And we assumed that that meant we were allowed to move our business to the property without applying for a site plan review. We were not trying to get away with anything. It was simply a misunderstanding. So please do not hold this against us when making the decisions. I read in the ordinance that the idea is if somebody is out of compliance, that you're supposed to help them get into compliance, not hold it against them or penalize them for doing the wrong thing, right, initially. As was mentioned, we made the decision to move the tree service division off of the property. So that leaves on the property the firewood processing division. To process firewood, we need to be able to bring logs from other sites and stack them until they are processed. It doesn't really make sense to have to be cutting the firewood from the own property because you would run out of firewood really quickly unless you had 1,000 acres or whatever, which we're not going to be able to purchase in this county. We have a commercial firewood processor, which is able to both cut and split the logs in the firewood. We have a skid steer on the property that is used to load the deck of the firewood processor. We have a couple of different size dump trucks used to deliver the firewood. There is a gas tank and a diesel tank needed to run the equipment. A small storage shed and 2 metal storage containers are used to store tools, etc. In the township meeting last night, Mr. Yerman made a statement about the zoning administrator always remaining neutral in her decisions, and he applauded the job that she does. I would like to clarify that we are not disagreeing with this statement that you made. We are just saying that in this instance, the zoning administrator made an error in this use analysis. You should have received 2 letters from our attorney outlining the reasons we should be allowed to use this land for this use. I'm gonna just touch on a few of the major points of the letter. The basis of our disagreement with the evaluation is a self-created definition of harvesting. There is no definition of harvesting within the zoning ordinance. Instead, staff has created their own definition, in which they state harvesting by definition means a gathering of crops, which assumes, and that's the key word right there, which assumes that the crops are located on the property where the use is occurring, not being brought in from another location to be processed. Zoning staff makes no reference to any outside source, no cases in Michigan law, nor any jurisdiction for creating these assumptions that the harvest is limited to only crops grown on the parcel in question. Thus, we are being denied the use of activities which otherwise would be allowed only because staff has created a restriction and basically added terms to the ordinance that don't exist. They adding terms that they weren't there to say that it has to be cut in this property. We acknowledge it says timber harvesting, just like for a farm, you might say, on farming, you're allowed to harvest crops, comma, raise livestock, comma. It doesn't mean you have to be doing all of those things on that property, right? There's a comma in between, it doesn't say you have to be doing it, each of those things. Turning to the definition, it is true that harvesting means to gather in crops. However, when the harvest yield is processed, there is no basis for the assumption, once again, that crops are located on the property where the use is occurring. Suppose a farmer has crops on parcels which are located near each other but not connected. Is the farmer prohibited from moving his crops from one parcel to another so that all the crop yield could be processed together? Of course they are not. Further, could a farmer purchase crops of a neighboring parcel and then process them on their land? Of course you could. The same should be true here. We should not be limited to processing only trees grown on our site. Another reason we believe we should be able to use this land for the forestry production is because the precedent set when you approved this same use on a parcel zoned FF1 for Robert Drost. I hope you have had a chance to read the second letter from our attorney about this. He explains why this precedent is significant despite, and we understand it was part of a PUD. We expect that neighbors will share the reasons for asking you to deny this application. Please remember, neighbors' input should not be taken into consideration when deciding if we fit this use, because this is permitted by right. Instead, they can make suggestions regarding the layout, shielding, and so on. We would like to say that when choosing the layout of our site, we place the logs and equipment as far from neighbors and the property lines as possible. We are confident that any realistic concerns can be addressed, and we are open to suggestions for the best way to move forward together. If you have any questions for us, we are happy to answer them. And we just certainly urge you to reject the staff's recommendation that the site plan be denied based on these erroneous, inconsistent definitions, and instead approve the plan. Are there any questions for us?
Not this time, not for me.
Happy to answer them.
Anybody? This time? Set? Okay, this time, we'll take comments from the audience. Again, 3 minutes and we'll, come forward for name, address, and so forth. Anyone like to speak on this case this evening?
I've been asked to speak on behalf of the Dows, and I'm an attorney that they asked to specifically review and discuss a few matters. So I will try to keep it just directed towards some of the legal matters. I'm sorry?
Name.
I will, yes. My name is Mark Hillal, Hillal. Sorry. So I try to keep it directed to just some of the legal aspects of this. First and foremost is that, as was stated by the staff presenter, the zoning administrator's obligation and duty and actual authority is to make interpretations when there aren't definitions. I think that the staff recommendations were very thorough in their making their describing their basis for making the statements that they made in terms of supporting their interpretation. The genesis of all of this ultimately seems to go back to the fact that if you are harvesting timber on your own property that you own, then obviously that is something that is allowed. There are still some restrictions in doing that. For example, if you're going to do it over 6 months, there are some permitting requirements that were described again by staff during their presentation, so I won't go through that. But it makes sense from a perspective of your relationship to your community and the people who live around you. Timber harvesting is a very noisy operation. If anybody's ever experienced that themselves, then you're aware of it. If you haven't, it is a very noisy occupation. And it also creates a lot of things like water runoff, because as you timber, as you move trucks, big trucks in and out, you destroy the filament, the character of the ground underneath. It becomes softer, muddier, etc. In this particular area, for example, rain runoff is already a problem for some of the people in that community. For example, the Dows had to add at least 3 new sump pumps to their home just to keep it from sinking more into the ground. It's a very wet and swampy area. And they are downhill from where this operation is designated to occur, and actually is occurring as we speak. The fact that the zoning administrator made this interpretation, and again, I stress that it's very thorough. They really did a very interesting to a lawyer, from a lawyer's perspective, and thorough job of relating the different areas in the zoning ordinance that supported their interpretation very well. And it also makes some common sense. If you're going to have a commercial industrial occupation like this, it should be an industrial zoned area. They're not saying we only want to do this for a year or 2 years. That what would commonly take to maybe do a 10-acre parcel. This is an industrial use that they're actually asking to have approved. So it's not fitting with the character of farm forest from just a common sense perspective either. Mr. Blodgett is someone who I'm familiar with. I like him. He's a good attorney, but I respectfully disagree with him that there's no case law that supports the zoning administrator's interpretation here. There is a case directly on point, in fact, and it is a Court of Appeals case, a Michigan Court of Appeals case, Blomaker versus Dumont. And in that case, it's the same exact facts here. People wanted to take timber from offsite, do production of cordwood, etc., and then sell it offsite. And the Court of Appeals found that to be a nuisance per se. Okay, so for example, if Mr. and Mrs. Dow decided, no matter what this body determined, no matter what the Zoning Board of Appeals determined, that they wanted to take them to court, there's at least one case that supports their claim that what is occurring on that property is a nuisance per se. So I respectfully disagree with my colleague there, and I haven't had a chance to read his letters. I haven't seen them. I downloaded what was available from the county website, and that's all I was able to do. So I just would ask that that this body be very careful about going against what the zoning administrator has already determined to be her interpretation. It was well thought out, and without a counterbalance of well thought out objection and using similar language from an analysis of the zoning ordinances, it could end up mired up in court as well as just becoming a problem. You can't just simply say, we disagree. That's my understanding of the status of zoning law. You have to have a body that has the similar authority of interpretation. And right now, my understanding, it's the zoning board, the zoning administrator makes the interpretation, and the zoning board of appeals can change that. And there is case law to support the fact that it is a nuisance per se to timber property or logs coming in from off property onto your property. That's production. That's not harvesting, and that's what that case law found as well. Thank you for your time.
Thank you. Anyone else on this case?
Please.
Yes, sir.
Matt Bree, 5450 Rustic Road, which puts me right around the corner from the operations. Other than Mrs. Figg's parcel, our backyards would come together. Clearly, it's an interpretation issue, and clearly there are going to be some differences of opinion. When I first heard the logging operation, I became curious. I went around the corner. Oh, somebody's logging off their property. Got me to thinking, wait a minute, this property lines, that doesn't fit. Because that's an open area, there's no logs there, it would have to come off somebody else's. Assuming it was the next parcel up the hill. Clearly I was mistaken. Because this operation just expanded exponentially. There are trucks up and down the road. We're not harvesting anything here. We have a commercial enterprise where we purchase products, we bring them in, we process them with noisy equipment, we then ship them out to make money. It's not like your neighbor is logging off their back 40. I'm okay with that. Everybody has a right to do that. But if you are farm and forest, I don't believe, in my opinion, you have the right to disrupt and cause the nuisance that a commercial logging operation does. Does it adversely affect the property owners that are adjacent? Would you want to live next to it? If Mr. Still or Mrs. Fig decided to sell their property, do you think it'd adversely affect their property values? I certainly do. I think that's a nuisance. It doesn't fit this neighborhood. On the application, the applicants show an address on Pearl Lake Road. It's a little over 14 acres. That's not farm and forest. And it's adjacent to Foxwood Industrial Drive. Why did they pick 10 acres in a residential area to start their commercial enterprise? It's beyond me. It's not right, yet the operation continues. There are no porta-johns. There's no containment system for their fuel tanks. They continue to operate. Their address is Rustic Road now for their company, even though they've been repeatedly denied. I don't understand it, and I'd like you to take a look. Thank you.
Thank you. Anyone else on this case this evening?
If there's not any others, I would like to refute.
Last call, anyone else like to speak on this case this evening? Okay, now you have time to respond back and address it to the board.
Yeah, I just want to explain about the case the lawyer was speaking about. We also have read and looked at that case. And that case was a different situation with the new situation. It wasn't the words used there were not forest products processing, forest operations. It was just, they were debating the word forestry only. And this products processing part was not there. So it was a different situation, and they were looking at if under the Right to Forest Act, which is sort of similar to the Right to Farm Act, if those firewood production fell under that. And that was what that was ruled about. It wasn't about forest products processing. This is a different thing that we're talking about here. So just take that with a grain of salt about this other case, because we have also looked at it. And it was talking about something different there. It was talking about a forestry, the word forestry, not products processing. So just wanted to explain that.
There was a question brought up about the containment system around the fuel tanks. We're not required to have a containment system around the fuel tanks because we are less than 1,320 gallons.
We did check into
We
that.
checked into that, and we have not put a porta-john in there yet, but it's on the site plan, so.
And we have been told that we could continue to operate out of the property, so we're not breaking any rules or going against anything we've been told to continue to operate there. We have been told by county staff that we were allowed to continue to operate.
Thank you.
Okay. Thank you. Okay. Now, back to the board discussion to touch on that, I don't know, the revised, Bear Creek update on the fire does say containment for fuel storage from Al Walsheimer. January 21.
Did not see anything there.
The address sign at road containment for storage, fuel storage, this review is based on limited to the information presented on drawings and or materials submitted. Matters not presented within the construction documents submitted, nor items not requested for review, which is required for granting of permits, are assumed to be reviewed and inspected by others in consideration part of this review. So that was just, maybe didn't get this.
Yeah.
Al looks like he wants it done, so.
Yeah.
And I guess you can get with him on that.
Yeah, absolutely.
And just for clarification.
Yep.
Yeah, you can do it.
Okay. Discussion.
Yeah, I
Yes,
mean,
sir.
this has come up before in other cases, and it doesn't change the fact that we're here, but, you know, going back to the use by right and site plan review, you know, my understanding, and I could be wrong though, but if it's a use by right, I'm not certain how the applicant, how the business would know they need to submit a site plan. A lot of times when there's the asterisk, it says subject to other provisions, but for use by right, other than construction of a building, which I understand, but in terms of the use of you know, portable equipment and vehicles, I'm not sure, so that exists, but that's not my point. My point is, if it was a use by right with site plan review, that would not trigger a public hearing. Like, we wouldn't be here. If it was used by right, they reach out to the county, they submit a zoning permit if something they're doing involves zoning, right? And then that would be reviewed by staff. If there's an interpretive element, we have it's actually stated in here, pardon me. Yeah, so for our site plan review standards, the planning commission and zoning administrator in consultation with two designated planning commissioners shall approve an application for site plan, finding the proposed site plan complies with all applicable provisions. Obviously, that's not the interpretation of the zoning administrator, but I just want to acknowledge this particular use by right, does not necessarily trigger a public hearing around this case. So that's one thing that I think is relevant. This case has gotten a lot of engagement, but in some ways it could have been handled administratively, although that wasn't the determination of the administrator.
I think on that, you know, reading the background.
Yeah.
Which I'm sure you did.
Yep.
They're found out of compliance on became a commercial use on a property like the states, enforcement case. They came in and talked, like they said. Administrator was, what I'm understanding is, applied for a special SUP, special land use permit, back in November, December. denied on November the 5th, of 25, by this board. I was not here, but, followed it at Bear Creek Township. Following SUP denial, owners notified planning and zoning staff that the tree service business would no longer operate on the Rustic Road property, which they stated. And they submitted a new application for site plan review, identifying forest products operations. So they initiated the site plan review.
Right, but I'm saying the enforcement case in the first place, like if they're operating.
By use by right, they didn't need to, but apparently, or not apparently, staff.
Initiated an enforcement case.
Correct, because of their interpretation, if I got it right.
Actually, there's a couple of things I could, like to correct on that, if I could.
Go ahead, you're probably better at it than.
Yeah.
I'm just reading.
First of all, as far as requiring site plan review, I don't dispute that people don't always know that they, even a use by right requires site plan review. We acknowledge that and understand that, but it is clear in the ordinance, at Article 20, plot plans and site plan review, there is a section, uses requiring site plan approval. Site plans are required for the following uses: all new uses or structures except single-family or two-family dwelling units and accessory structures to two single-family or two-family dwelling units. All other uses require site plan review. If it isn't a single-family or two-family dwelling, it requires site plan review. It's very straightforward, and additionally, the reference to administrative site plan review, there are specific qualifying conditions to be able to go to, because there's different types of site plan review, and administrative is one of them, and planning commission review. But this planning commission review is required on any enforcement actions, first of all, and this initiated as an enforcement action. And then if, you know, we can also look at qualifying conditions where it's essentially a minor change to the plan, so.
Excuse me.
This is all in Article 20.
Okay, that's what I thought.
Yeah.
Thank you, go ahead, Laura.
So, that, first section that I don't know if you want me to reference
No, you're
the section
good.
for you. Yeah, but section 20.01, uses requiring site plan approval, that's where it's very clear. And then the section 20.07 is application process, and that's where it goes through when administrative review is permitted and when planning commission review is permitted. And this does not qualify for administrative site plan review. It did not require, it's used by right, so it is not a special land use, which does not require a hearing, which is why it's on the agenda under site plan review rather than public hearing. So just to give you, clarification on why it came to this body.
Thank you.
Yeah. If I could, Mr. Chairman, just a couple other clarifications that I just think are important to point out. I understand there's definitely some confusion on the interpretation, and there's been multiple meetings and emails, but I just want to make sure that it's clear that, and I have the emails here if there's any questions, but on January 7th, I did get copied on emails between Tammy, the zoning administrator, and the applicant, asking for clarification on the review process and interpretation. Asked if Tammy agrees that removing tree service allows them to fall into the forestry category. That was responded to on January 9th. Noting, some things that were seen in the initial review. Noting that the request was forest production operations, which I think, I can speak from my standpoint, kind of caught us off guard. And then on January 20th, when the zoning evaluation was completed, that was sent to the applicant. And specifically, that email noted that that the zoning administrator did not agree that the site plan review would only be about the site plan, that the use would be in question, so, and then there was a phone call on January 21st, and that, you know, that was when some of the ZBA, you know, interpretation was discussed, and that is consistent with, how I answered questions by the Bear Creek Township Planning Commission, that the zoning administrator has the authority to do the interpretation, and that if a formal interpretation was requested, that would go to the zoning board of appeals. And that was the intent and spirit of that discussion. So I just wanted to explain that that's kind of where we were. Like I presented today, you know, if you can cite specific parts of the ordinance that you believe do fit, then that, you know, that certainly can occur. But I just wanted to explain that. I also don't know of any time that the applicant was told by county staff that they can continue to operate. Was there, Tammy's not here to speak for herself, but I just can say from a staff's perspective in the office, if there was not actual enforcement action or activity happening, that didn't mean that it was allowed to continue. And in fact, I think what we observed was that the use like expanded in that time. So I just want to offer that because it is difficult to, you know, I just want to offer a couple of clarifications from that standpoint. Again, there could be clearly some misunderstanding or confusion there, but that would not be the intent that they were told to continue.
Can I ask you a question
Sure.
on that? Okay, so if they say they think they were told they could continue, you're saying they were not told they continue. Do you have records that show that they were told to stop?
Cease and desist.
There was not to my knowledge, there was not a cease and desist, but they were notified in writing after the denial by the planning commission for their use. And also, I did see an email where it referenced that the tree harvest or the tree service portion of the business would be removed, but that hasn't been approved on any other property too. So again, just a notation that there are some existing enforcement matters.
So when we voted denial before, then a letter went to them formally saying,
yes,
we voted denial.
With the draft minutes.
Okay.
Yep.
And then what were they supposed to do after that?
Well, like we've said, that working towards compliance is always the goal. And it was a matter of other meetings where there was discussion about forest products processing limited, what did the limited mean? And I was part of that meeting, and I know Holly knows I was there too, and we have an email from her saying, I'm not sure what that meant. And I can just offer that I know Tammy was explaining that I don't see it that way, and you will need to explain how you believe you're limited. In what way? Because we're talking about a definition in Article 2 that says forest products processing. It does not define limited, but the schedule of regulations includes that. There is some intent there. And so the zoning administrator's role was to try to understand what that intent was and offer that interpretation. That struggle or that difficulty was discussed with Holly. And so I think the thought was we were going to get a new application that explained in the narrative, in the application, how what is being proposed fits with limited, or how this really fits in that forested category, because from every meeting and every email that I've been a part of, that has been consistent, that it did not seem to fit from from the zoning administrator's standpoint. And like I said, I can only go by the emails that I have and the meetings that I sat in, so.
So the zoning
yeah.
office was looking for a description of what the applicant would characterize as limited.
Yeah, that was suggested, that
Okay.
if you believe you fit in that category, and that is your understanding of it, then you're gonna need to submit an application. What we got was the exact same site plan with, and no intention of, it was the same site plan, so, anyhow, it was the same site plan, and it was, the only difference was Forest Products Processing Limited wasn't mentioned in the application. So it's hard to know what to do with that, okay? So, that was why the evaluation went. There were multiple discussions, and, I thought, from my perspective, on January 21st, when I was copied on, the email with the ZBA packet materials, and that explanation of their authority in making those interpretations, I thought maybe that was the direction that this would go. But, do you have any other questions? Just wanted to offer a couple of clarifying points.
Mr. Chairman, can I answer?
Thank you.
Speak
Thank
to
you.
those?
1 second. You good on that, Scott?
Yeah.
Yeah.
I would just like to say that I specifically talked to Tammy the day after we were here last time, and that decision was made. And I said, what does that mean for our business? Do we have to move off of the property? I'm sorry that this wasn't recorded, but this is what she said to me, and I'm sure she would confirm that, was that you just need to be moving towards compliance, which means, we talked about last time, having a different way to apply or whatever it took to come into compliance. And her comment to me even, and I specifically remember her saying this, I wouldn't say I would give you up to a year, but really as long as it takes. Exactly what she told me on the phone. And you do not need to stop doing anything you're doing. You may continue to use the property, which is why we have continued to. That is exactly what she said to me the day after. I specifically called and asked her that because we needed to know what we were gonna figure out for our business. So I specifically asked her that. In the meeting that Laura is talking about with the 3 of us, I did come in there with trying to understand. I thought as them being the zoning people and professionals, they could explain to us why we didn't fit there. This whole long presentation that you got tonight, we were never explained why they even thought we didn't fit there. They just kept telling us they thought we should be a contractor's use, but they never explained why we didn't fit there. I didn't hear any of this until now. I mean, it doesn't seem like it should be our deal to have to explain why we fit in there. It seems very obvious, as you said, cordwood, pulpwood, products processing. What more did we need to explain to say that we fit there? We only applied under the contractor's use the first time because they told us to. And they told us that's what we'd have to do to have a building there in the way distant future. But it was not our intention from the beginning. We were encouraged to do that. We didn't understand why even, because they didn't tell us that. This has just really been a big mess of communication and been very poor. And
well, let's not, I don't wanna get into too much of that.
Right, so
because-
they just never
because it's a
explained.
he
Okay.
said, she said,
Right.
I was not there,
Yeah.
that'd be something you need to bring up with staff and so forth. I don't wanna hear any more
Yeah,
of
so
that, I'm
that's-
sorry,
so
because,
that's that.
because
Yep.
people aren't here to, and we're not into that type
Okay.
of discussion. So-
Okay.
But I
So
truly
that's
believe
just trying to answer
they're
what
trying to
was
give
said.
you,
Yep,
give you direction, so.
okay. Well, it was very unclear.
Okay. Thank you. I understand frustrations, but we're not gonna get into that, so. Okay. Anybody else? John?
I don't have a problem with the continuation. That was good faith on their part because I voted against this the first time. Why? Because it was a contractor use, SUP, specifically tree service, without a residence.
That's correct, that's
That
the
was
minutes
the
I read.
reasons we denied it, so if they thought the other was fine, whether it is or not, I have no problem with it. I mean, that's not an issue that they are continuing, seems to be brought up, until, I mean, they applied, they removed the contractor's use. That looks like a good faith effort to me, so that is not an issue for me.
Yeah, and I think, I don't have the minutes from that meeting right in front of me, but my recollection was contractor's use requires a residence on site, and there wasn't that, and so it didn't meet the criteria for a contractor's use.
I think that's what I remember reading.
It wasn't inherently that the use of log processing wasn't permitted, it was that the contractor's use requires, a residence, and the applicant cited that they were advised to pursue contractor's use, because there were other examples of this where the result had been favorable. But then it was discussed at the hearing here, the meeting here, that, those other instances that resulted in an approval, without a residence on the parcel, had, each one seemed to have some degree of extenuating circumstances where the board accommodated it. Like, they weren't on that parcel, but they lived nearby, or they weren't on that parcel, but a staff person would, and so there were reasons. So I think at the time, like, again, the contractor's use was perceived as a cleaner way to get there. But the
But
issue
that was
at hand, by staff.
Staff, yeah.
But the issue at hand in that conversation was not really about the forestry products processing, it was just that there's no residence, and so, so I think that there wasn't really much conversation, as I recall, about the definitions of forestry products processing or operations or log storage, because we weren't even in that section of the ordinance, we were in the contractor's use, which was a wider umbrella under which to operate. So that's my recollection. I feel like I might have even said at the meeting I wasn't sure why they weren't in this use, because it was a use by right, but I don't have those minutes right in front of me, I apologize.
And I don't have those, I don't recall what Bear Creek and the Township Board, either without going back on those. But that contractor's use, like you stated, they were different. The parcels, I believe, it was talked about other properties, parcels were much bigger. They were 40 acres, 80 acres and more. That weren't a 10-acre parcel, I believe, was talked about within in that farm forest residential type, in
That could be.
master plan calls for that as rural residential, I believe it was too. I don't recall everything in that conversation, but it looks to me like we're getting a lot of he said, she said, not sure. I don't know where we're gonna go with this, but possibly, we may wanna postpone until other staff members get back here, we get a timeline and get some things all laid out. Or that's, I got tons of paperwork here, tons of notes, so, that's just a thought, but we can further discussion or not,
Before you do that.
No, that's,
I have
I'm
a-
just,
Before we even entertain that.
Correct.
I mean, I think there's an elephant in the room here.
What's
It's
that?
all this interpretation is lacking, we'll interpret that, it's lacking all through here. Where's that go? We'll go to the zoning code or the definitions, and we're relying on Tammy, maybe? Or we can look at the code, or it can go to the Board of Appeals, or what about interpretation based on previous interpretation? What have we done for the last 20 years? I I mean, I sit here and I look at their operation, I think they're off base talking about Drost. Because there's exactly those things scattered. I remember being approved from Gruler Road all the way to Small Street Road. And what did we do with those? We actually have one in limbo right now. Same thing, remember Woodland Road? He went to sleep because the operator hit himself with a chainsaw. So it got put on hold and so far it hasn't come back. But that is a 10-acre piece that he is bringing in timber. 10 acres and according to Ariel, about 4 acres of it is covered with logs. Woodland.
Up by the Brutus.
No, we have an application sitting there. We have one on Small Street Road, no residents. That's actually a 5-acre piece that the county approved. 3 acres is covered with logs and equipment. So that seems to be missing in our discussion is what do we do, what have we done? And we're starting to scratch, looking at this code and saying, okay, what does this mean? What does this mean? What has everybody interpreted in the past? And what do all these uses that we approved, how would they fit in this code that we're, interpreting? So if you wanna postpone and go, we gotta look at what we've been doing.
But if those cases were approved, then that might be an instance in 3 acres of logs and 4 acres of logs. You know, this site plan indicates 15,000 square feet, so 1/3 of an acre. Maybe, I mean, that would seem limited compared to the other operations.
Yeah, that we approved. And the one that is pending is actually just site plan approval.
Right.
It's not special use.
That's in.
Is it an enforcement action?
That's a neighbor.
Is that one an enforcement action?
Yes, because of the sludge pit where everything they don't want to process goes into a big pile and they're smoking the neighbors.
But to your point earlier, the Dross case is totally different case.
This is totally different.
Yep, the Furman case, which we talked about, I believe, back, that was a totally different case.
Well, the first one I remember is Sturley on Gruler Road, I think it's gone now. That was exactly the same thing, bringing in
before
timber,
my time.
sawing it into the fire. I know, I go there, slow people's time.
And if that's Sterling Road, that was a bigger parcel too.
Well,
It was
Gruler.
back on Gruler Road to the back. Or he was enclosed in his building there too, I think, if that's the one I'm thinking of, I'm not sure. Anyway.
But my point is, we have all this precedent, we have been having. So that's something that is missing in our interpretations.
John, do you think that producing firewood on the site falls under the processing?
I don't know what we're gonna do with this, because there's so many sidekicks out there right now. It's happening all over. I mean, I can just look back at what have we approved, what have we looked at. I mean, industrial zoning, no, that's just, we approve them in farm forest because of their nature.
It would seem like farm forest is where you would process forest products.
Yeah.
But to that point, if we, just kind of thinking back at something, I don't recall everything, but there was proximities to housing, homes, and locations were all thought into those. I mean, without going back on minutes. And there was 5-acre parcel that there was nobody around within.
Well, the 5-acre parcel there was.
Yeah.
And there were complaints after it got approved that nobody projected.
But I don't recall, but this case is got its, everyone's got a little different twist on it, so. Distances, sight distances, sound distances, all, and I'm just throwing all that out there. The site plan needs, if we're to move forward, there's lots of stuff that has to be looked at, in my opinion. We're not talking that yet right now. Anybody else?
Chairman,
Yes, sir.
farming, does not require a site plan review. It's exempt from, Emmet County code. This property is zoned FF1 Farm and Forest. And, it seems to me this forest production is in the same category as farming. I don't know why it requires a site plan review. That's my opinion. We do have a county attorney on staff, but we could, put that question to him.
I think Laura touched on that earlier, the site plan review standards. That, those are three things on our motion, so I,
We got two decisions tonight here, right? One, if we want to do a site plan review, and then two, pre-prepared motions pertaining to approval, denial, whatever, of that site plan review.
and that's the way it's advertised, as site plan review for this forest production operation.
So one, we gotta decide whether we want to go to site plan review.
That'd be correct.
And that's where Bear Creek Township stopped.
Correct. They made the decision not to go any further to
Right.
site plan review, or not even go to site plan.
Right. If we decide we do, okay, fine, then we could potentially then postpone that site plan review until we get these other details and things.
That's
But I think
correct.
we do maybe need to make a decision, yay or nay, do we even wanna move farther forward in the discussion than Bear Creek Township decided they wanted to?
And that's correct too. Do we wanna look at the site plan, or stop here, or postpone it? Yeah.
And it still could go either way, anyway, whichever way, I mean, depending on details and discussion and all kinds of stuff. But I think it's, my personal opinion, I think
Even
it's
if we
worth
wanna
looking
continue
into.
with the site plan, I think we should, if we decide that we can't make a decision on whether it moves forward, we have to know why, so we can get that information.
Say that again?
If we decide that we wanna cancel because we need information for the first phase, which is, can we move forward?
The use,
Correct.
determining
Yeah.
if the use is in.
But do we have a consensus on whether it should move forward?
How would we
That's-
determine that?
That should be fairly easy.
Well, it's either like a unanimous consent or make a motion. Yes, we wanna have a site plan review, or yes, we wanna move forward to site plan review.
Laura, can you help us out here? Or,
It
I
sounds
guess
as if,
we're debating it from what I understand, we're
yeah,
not debating
there's,
discussion.
yeah, I would say maybe there's two different ways to go forward. One would just be a discussion where you, kind of take an informal poll and find out what the consensus is if you wanna move forward. The other option would be, as I, noted earlier, that, if this planning commission believes there are, specific elements that is tied back to the zoning ordinance that shows that this use does fit that category, then that could be put into a motion where you state those specifics. I think Bryon was working on something that, was starting to develop why, the use does fit in that use category. And if you want to make a decision first on that, by motion, I mean, you certainly could. But, or at least, my recommendation would be that you know what you're moving forward with, because I think John made some good points. If there's more that you want to explore before you even decide if it fits the use category, or do you feel like you have enough, you believe it fits the use category, but state what those are so that it's not arbitrary, it's clear on what grounds, you're in agreement.
And I'm kind of reading back in the minutes to some of those same questions were asked at Bear Creek Township. It states, Maru, is that how you pronounce it? Stated, zoning administrator and staff find that the use occurring on the subject property does not fit the forest products processing limited, forest production operations, log storage yards, and related use categories, is not consistent with other harvesting and agricultural uses permitted by right in Farm Forest District. For these reasons, the applicant was originally guided to pursue special land SUP land use for contractors' use. Then goes on, and then Radovich asked for clarification from Moreau as to the path forward with this case. This is, I think, where we're going. She asked if before the planning commission reviews the site plan, should they first determine if it meets the use? One. She then asked if it is determined that the application does not meet the use, then is there even a need to review the plan? So that, I think that's where we're at. Laura stated that those decisions be up to the planning commission to choose if they wanted to proceed that way or not. Laura stated that she has asked that the planning commission accept and understand the details of the analysis in this case. She said that it's important because it is not a fitting application when reviewing the details of the site plan would not be necessary. So I think that's where we're at if we want to move forward or not. And I recall that's what the chairman, Mr. Brown, asked on on board discussion. So there's other stuff in there and everybody had a chance to read it. So I guess that's where we're at. I shouldn't say I guess. Sounds like that's, do we want to move forward on this case? With the way it was zoning administrator and staff presented it, we want to, if I'm saying this correctly, move on forward with site plan review, or I guess we could postpone possibly for more information from staff or legal counsel. I don't know. Just throwing that out there. You've been here longer than I have.
Well, I mean, if you postpone because we need interpretation on some other avenues, like, we need more information to make the decision, that we can still postpone. But if we have enough, if we feel that we have enough information to look at the site plan, and there's enough of it, then that takes care of that. I mean, we're still down to the same three options. Deny it, pass it, or table for more information.
I don't know what more information.
Well, more clarification of these interpretations, if someone needs clarification. I don't personally.
Yeah, I mean, that's kind of what I was getting at, is it would be postponing so members of this board feel like they understand it better. There's not gonna be new information from the applicant.
Right.
Yeah. So maybe the question to this board is anybody unclear on what's being discussed?
Because for me, I don't put as much weight of determination on the word harvesting as is in the staff evaluation. I would put more weight on the word operations. Yeah, and that to me is a completely different context.
I
Yeah.
would agree with that.
To me, this feels like the appropriate land use category, because
It does for me as well.
the sawmills, and, you know, veneer mills, that's a much higher intensity use. That's like a, you know, Monetize over in Bay Harbor, like a very, you know, that's a much more intensive use. And then on the lower end, you just have timbering and harvesting, which is
Yeah.
not, you know, a use. So
Yep.
to me, this kind of use, which is middle, it's not veneer mill and it's not just cutting trees, is why this category exists.
And that,
Yeah.
what you just said could suggest why that word limited.
My understanding was that Forest Products Processing Limited was to draw a distinction between forest products processing in this category and the veneer mill sawmill
Yeah.
of the more intensive category, which comes with much stricter setbacks.
And I somewhat agree with you, but limited, I believe, is more of a temporary use than a straight use. That's my
That's a fair
interpretation.
point too.
So temporary compared to permanent, are we looking at commercial use, or are we looking at a temporary setup to process firewood at a location for a 6 months time, then we're gonna set up at another location to process firewood, so
Yeah.
it's all about interpretation,
I
so.
thought that,
So-
and that's where that definition gives the examples of the pulpwood, cordwood lumber seems like the lowest use. And then the sawing and converting into ties, posts, pallets.
Yeah,
You would
wait a
never,
minute.
yeah, sorry.
Keep going in those sentences, because for me, the and like products,
Yep.
and then the and similar products opens the door to other stuff that.
And you would never temporarily set up a pallet factory. Right, I'm just saying, like, these, the first one, it seems to me is laying out the three things, like, there's the harvesting component, storage yards, sawmills, then there's the examples of what these could be converted to, and then there's the sawing into ties, posts, pallets, and similar. It's like the three sort of tiers, and in this case, you know, firewood would be in the lower of the processing tiers, you know, a pallet.
Limited tiers for that.
Correct, I've been to a pallet factory, you would never temporarily set one up, and it doesn't look like this. That would be closer to a, you know.
So where would this one fall in those three?
This one would be in the limited in the pulpwood, cordwood lumber, not into sawmills, not into pallets, posts, ties.
So limited is indefinite.
Yeah, I think limited is the intensity of what's being made, cause all of these don't have a temporal
And
element.
without the word limited being specifically defined in here,
Well, we're also.
that makes sense.
Interpretation.
I can't wrap my mind around, we've obviously had this issue since 1995 or 20-some years. Why do we still have to be interrogating it? Why have we not come up with a little more definitive description or definition of what this is? We're 25 years into this problem and we're sitting here trying to figure out what the heck this means. How does this happen?
1972.
You're making the point even more.
John, did there used to be more forestry categories? I thought when we cleaned up the land use matrix, we combined two, but I
don't know, that limited kind of throws me, because how could limited be temporary when we already said temporary is used by right?
right.
So,
It feels like limited would not restrict something beneath what's already allowed by right.
right. Well, that's, you know, how could this go on? That's where we have to look back and see what have we done in the past, how did we do? That's what's missing in our interpretation.
Well, I agree with you, but if we've done it wrong in the past, that doesn't make it right today.
We can change it, but we never did.
Which is my point. And I think if it were, you know, really black and white, we wouldn't, it'd be easy. We wouldn't need a board.
Right, I mean, that to me is why I think this board is here, is to answer these questions. Because you could, as stated, you could never define everything.
So by saying that we will move forward to a site review, that's all we're doing, is going to a site review, right?
Correct.
Could, I mean, we could, I guess, put in the motion that we wanted more definition, I suppose.
But the ordinance answers the lack of definition. The ordinance says where there's not a definition, the normal meaning, when it's not defined, the normal meaning applies.
Okay, so
Customary.
is your normal meaning the same as my normal meaning?
Well, that's why we're here,
Just
there's
had
9
that
of us to
discussion.
decide
Right,
what our normal
that's what I
meaning,
mean,
or
yeah.
customary meaning is. So, it feels like we should probably discuss the site plan review. But I'm open to us doing sort of a, I don't think straw poll's the right word, but understanding who does or doesn't want to.
Well, I'll put my hand up first, I would like to move forward on this.
Yeah. Wanna move to site plan review?
I do.
Shelley?
No.
Yes?
Oh, yeah, I mean,
No.
Right.
I'm having a hard time. I would say yes.
Chuck?
Am I in favor of the site plan review here tonight?
In favor of moving to discuss the site plan review?
Yes.
Yes.
I'll say no, just because of the customarily, referring to the zoning administrator. So,
interesting, that's as
I'd
divided
feel,
as,
I'd feel more comfortable, postponing, but that's just one person.
Well, if we say, let's go to a site plan review, can we then postpone it to review it at a later date?
Oh, sure, with other
yeah,
With more information?
then our motion would be to postpone.
Yeah, so this was
More
just discussing if we go to site plan review. Then, in terms of a motion surrounding the site plan review, there could be a motion to approve, deny, or postpone that site plan review.
That's where I would feel most comfortable from. I mean, I think there's a lot of things to take in consideration. I know we shouldn't rule by mob, but we have a lot of concerned citizens on this. I think we need to take the struggles that these people have gone through, and I think we need to, I don't see anybody here saying they feel comfortable just outright making a decision tonight. So I would vote to go to a site plan review and then postpone it until we get more information.
And if we do that, then we need to specify the more information.
That's correct. We're gonna go into a full-blown site plan review right now. That's what we're gonna do.
Okay?
That's what you want, guys, or I think that the consensus.
Yeah. It was 6-3.
Okay.
but it can be postponed.
Correct. The actual site plan review can be postponed for the more information people want.
Information on how it has been handled in the past, which was not presented in the interpretations.
So we wanna get right into the brass tacks of site plan review, or how, you guys wanna make a motion? We're gonna move into it, but postpone for X, Y, Z. Cause if we're gonna move forward, we're gonna take a 5-minute
Yeah.
recess.
Good idea.
So,
Well, and I wanna make sure too, that I don't wanna, the work by staff is exemplary and is detailed, and dear God, are we thankful for the information that they give us. So I don't want anybody thinking we're going, staff screwed
Well,
up, that's not what we're saying at all.
kinda so, I'll be honest with you, kinda so, that's what you just said.
Well,
We're not really leaning on it, so I'll be
No,
frank about it. Kind of, that's what,
Well,
that's
and
my
that's-
feeling on it.
and that's why-
my feeling, I'm gonna
And
tell
I
you.
get that,
So-
and that's why I'm saying what I'm saying, because I don't want that perception. I think this is great work, it just, I happen to disagree, and that doesn't mean
We
it's
all
shoddy
agree
work,
to
or
disagree.
whatever. It's still outstanding work, I have to disagree.
Could I support you up to a point, but then say, going back to an old township thing is, you don't have to go along with it because the commissioners and the planning commission have the ability to change it.
Yeah.
So we cannot say, yes, she's got it. We appreciate it, she did good work, but we don't have to accept it because we have the power to change it.
Yeah, that's correct.
We're gonna stand, recess for about 5 minutes. I guess it is 10:10.
I was reading that clock
Yeah, don't read
by
that.
an hour for the last hour.
10:10, you're right, it's on my phone.
Oh, it's on.
Thank you.
Oh, yeah, no.
I thought it was.
Okay, we're back to the, 25005, Bryon and Holly Willcome case. So we stand at, we gather, we're gonna move forward with site plan review. And we wanna move forward at this hour and get into this, or we wanna look at it, 30 days from now.
I just,
That's
yeah,
the discussion.
I wanna state that I think there's support amongst this board to postpone the decision on the site plan review, but I think we need to do ourselves and the members in attendance a service of making sure that if we're postponing, we clearly articulate what it is we want delivered before the next meeting, so that next meeting, we don't, end up in the same position. Does that feel appropriate?
I believe so. What, so if applicant needs to bring information? so-
Or
staff,
John mentioned
some staff review or
yeah,
something?
some historical context seemed relevant. The applicant's site plan has not changed a lot. I'm not sure what we would ask them to change for the next meeting. But if there are concerns, I would think it would be appropriate and just to mention those now. The fuel containment was addressed in Al's revised update, so I think that should be on the next site plan. I think possible porta-john location should probably be actual porta-john location. Or maybe just to understand from the applicant, there will be a porta-john and that's possibly where it would be, or that there would possibly be a porta-john.
There will be a porta-john.
There will be a porta-john that's possibly, okay.
Containment specifications, I would assume Al will
Yep.
want, and we would want at this board.
Yep.
How that's gonna be constructed and what specifications it's gonna call for that specific fuel storage, being that is a wet area. The ground slopes to the north, northeast, towards that creek that runs underneath their driveway. So
Yeah.
that's a real concern that I had when I went over there.
Personally, I think under the site plan reviews, a point D and F, I think it's important to protect the visual and sound creation from the neighboring parcels, and options provided are techniques such as screening, fences, walls, green belts, landscaping, sufficiently screened to obscure the view and sound buffers. You know, given the nature of this use, I personally, I think, a fence or a green belt would probably be effective for visual screening, but not for sound. So personally, I'd like to see an earthen berm constructed for this type of use myself. That should also alleviate some of the drainage concerns.
On this checklist, you can go down this.
Could go down that.
We've got, what you just touched on, location, landscaping, slash farming, if that's what you're, there's, wetlands identified, which is an NA, that needs to be identified on that site, for sure. Possibly a delineation report. If we can ask for that, or that goes to, legal thing.
You want a wetland delineation?
Possibly, I mean, it is, what, you got gases and oils and all this, I mean, the neighbors are already asking things, I'm just going down the checklist. Whether it goes any further, we have no idea.
Yep.
Soil analysis, I mean, that,
I don't think, I mean, that can just be pulled on,
same thing.
that can be pulled on, USGS.
Number 30, require landscaping, possibly snow storage management, waste receptacles, water well, septic not available, site grading, elevations, all that. An engineered drainage plan by a registered engineer possibly might be needed there because of the contaminants that could be on that site. Depends on how that, containment comes back.
Yeah, I mean, they're less than 1% on 10 acres. So
Processing.
if the fuel is contained, I think the rest will be alright. They need a sign, address sign at the road. And then the road, Godzik said, it needs a commercial curb.
And if you're going with that berm, you better be specific on what you're gonna ask for. Now it's gonna be addressed and maintained because we've gone through that on mines. They say, yeah, we put 3 trees, and they stick 3 little saplings up there, and there's your tree. So, we've had those cases. Just,
Mr. Chairman?
yes.
That's a good question. I was definitely looking for that, clarification on where specifically berming would, I have the site up right now, and noting the location of the driveway, you know, where exactly berms would be required.
And right there where the drive comes in, there is a little creek. I was out there today. There's water running in that culvert right there, just to the east, like about halfway down that driveway where it curls in there. And those water, or the containment, the gas and that is only, I don't know, 25 yards or so from that creek, 50 yards maybe. And that's running to the northeast, I would assume.
Yeah, so, in the packet, just Al's review was the updated one, because in the packet, it just says address side of the road.
I saw it.
And then the one from last
This was
week.
just on the
Yeah,
table
just,
tonight.
yeah, that was just on the table. But then the next page in the packet is from, the road commission saying it meets the site distances, 700 feet, you know, plus, et cetera. The driveway would have to meet all other commercial standards, including but not limited to concrete curbs, culvert extensions, and HMA or concrete hard surface. So I think for that creek running under the drive, that culvert extension would protect.
No, this is in sight probably.
The one
from-
like on that diagonal?
On that diagonal right there. There's water run right in that creek, and there's water running in there this summer.
Okay.
I saw it earlier this summer. Cause we're there to look it over. That's it.
So you want culvert and,
I'm assuming there's probably culvert there,
Yes.
don't look, but.
okay.
That's a tributary running towards, I would assume, Crooked Lake. Those are just things that, if we're gonna move forward, there's lots of things to be addressed
May I ask a
on this
question
site. Yes,
about the letter from the, and I can look it up right now, but the letter from the, road commission, I know he had originally written a letter before, for the contractor's use, but,
that's for the commercial drive, I believe, out the
right,
road.
but I'm just saying, I'm not sure if that's not what's expected for like a farm or something, doesn't have to have a culvert, that kind of thing. I don't think that was revisited, or that letter was before we applied for the forestry, so I'm just trying to clarify if we really have to put in the curbs and everything
I would
for
think
the farm and forest.
you'd have to take it up to the county, but I would think that if you're bringing that heavy trucks in and out of there, they don't want that asphalt. And probably speaking as Bear Creek Township, we don't want that asphalt busted off.
That would be something we could get an answer to.
That'd be a county
Yeah.
and a Denny Kaiser question.
We would, we
Because
would
that concrete, or that asphalt, we spend a lot
Do
of
they
money.
require it for farms? Maybe somebody knows that.
The road commission has jurisdiction over that.
Yeah.
Okay.
Yeah.
once we have a better understanding of how the use is being perceived, and what the road commission is not gonna be concerned so much about what use category it's in from a zoning standpoint. They're gonna be looking at the vehicles going in and out, but we can certainly ask them to look at it again if that's what is being requested.
Well, and the request is for forest production operations. So I think county commissioners, the road commission people, just off the top of my head, are not gonna wait for that. Maybe, that's unquoted, so.
I was just pointing out the letter was
They're
from
gonna
the
look
other
at forest
time.
production operation.
Yeah, I think we would need an updated look from the road. So just for the board, what I've
Yeah.
jotted down so far of things that we want addressed and updated before the next visit of this would be the fuel containment specs per fire chief's request. If there's a wetland delineation on the subject parcel, address sign at the road or the fire chief. Revisit the road commission for what kind of driveway entrance would be needed for this use. Some kind of acknowledgement of the creek under the driveway. What do we want?
That could be in that wetlands delineation, identified.
You want it marked?
I would think so.
Okay.
We would probably, you got your berms, you got.
Yeah, that's fine.
You got the whole site, the whole.
Yep.
10 acres is wet.
And then a berm placement on the north and west untreed portions.
Just in this photo here, the trees are really light in this photo compared to what's there now. I mean, they've grown up, but I understand what you're saying with that.
Yeah.
Yeah.
I guess
with the,
perhaps most ironically, I'm suggesting you not cut down trees to put on the berm.
Correct, that's, I mean, just
Yeah.
put it out there.
Yeah. Is there anything, and John, we want historical context?
well, that would be, yeah.
Yeah, but I'm saying the road commission would be effectively from staff as well. I mean, usually the road commission email originates from staff and then we look at the reply.
Well, that should be just a letter from James Johnson saying, no.
I guess for me personally, like regardless of who's delivering the information, I'm attempting to capture the items this board would like to feel comfortable making a decision.
You're gonna have to capture how you're gonna sound and noise the nuisance to the neighborhood there. I have difficulties with this site.
Sure.
Being totally upfront. We
How
have
tall of a
neighbors,
berm do you
and-
want?
and you read into different reports on it, the nuisances and peaceful enjoyment of properties and so forth, so. If it moves forward, there's gonna have to be some extensive screening, in my opinion, and soundproofing, and drainage plans, and, stuff that has to be addressed on that site. It all slopes to the northeast. The water slopes all the way from back, a mile back, down the hills. I'm just looking at topographies.
Yeah.
All something to be aware of.
Anything else we want? Jennifer, Kel, Scott? Chuck, you wanna see anything not already discussed?
In my opinion, if you, make them put in curb and gutter and berms and screening and everything else that you're talking about, that you're probably gonna put them out of business. My dad and I used to cut fireplace wood years ago when I was younger and sell it to resorts. We did not make much money on it. I don't see how they can afford to do all this and stay in business. That's my concern.
Okay.
And to address that, I'm not going there, but we do have to think about the environment, and we do have to think about the neighborhood. So, but point well taken.
Julie, anything that hasn't been captured that you wanna see?
Did we talk about, where the porta potty?
Yep.
Okay, that's on there.
Yep.
And what about an enclosure for the outdoor waste receptacle? and screens?
We can require it or waive it. It's pretty screened from the road, but it's that and the drainage plan can be, there's not a lot of impermeable surface being added, it's back, but we can require it.
And how tall should we have the berm?
I think it's a fair question.
And how wide?
Yep. Our typical screening is 6 feet-ish. I was thinking, given the nature of this use, maybe like an 8 high, with a plateau top that's maybe 6 foot, so you could conceivably mow it, pass back and forth to keep it from, or let it overgrow. I mean, let it grow up into the grasses, but I'm thinking most of the trucks, that would screen most of it, like, you know, you're thinking headlights and things of that nature would be at human level.
I think the log piles in the plan review are 18 feet tall.
Mm-hmm. But, I mean, if you're
Just a
standing,
thought, just a thought.
yeah. I think if you're standing looking at a 8-foot berm though, I don't know. I'm open to whatever. To me, if 6 is what we're typically saying, this is a case where I would be inclined to encourage 8. It is sort of where my head's at. That would, is 8 enough?
Under scribbling, to have a recoverable slope at 3 to 1, if you're talking 8 foot, and that's, you're talking a 54-foot wide berm, that's a lot. That is
Yep.
2 feet.
That's pretty, it's a lot.
Yeah.
Do we know, you know offhand how tall the one is surrounding Helmers, the former Daniels Pig and Dig Pit? That one was done really well.
With the base on the height of the.
I know that one already sits proud before it's done, but that was, to me, that was an example of one done, you know, well.
Well, I'm just saying, you know, 54 feet up there, you're gonna lose your trees.
Yeah. Is that why the typical recommendation is more like a 6 with trees on top?
Yes.
So you get that height without having to achieve the slope?
You know, the Flynn's on the other side of the road, they've got, it's probably 8 foot tall, that trees are growing on it.
Yeah.
It's gonna be very challenging to buffer that. Okay, where are we going? Anybody else got anything? No. Alright. Entertain a motion.
I'll take a stab at it, but please, if I miss something, speak up. I'll make a motion to postpone case PSPR 25-005, Bryon and Hwy Willcome, for site plan review for a forest production operation, log storage yard and related use at 5722 Rustic Road, section 36, Bear Creek Township. Tax parcel 24011636400008, as shown in the site plan data received December 30th, 2025. To provide time for the following additional information. The applicant to update the site plan with the appropriate fuel containment specifications per the fire chief. To assess any wetland delineations on the site. To provide an address sign at the road. To communicate the Emmet County Road Commission for the appropriate driveway entrance. To ensure the creek under the driveway is included in the wetland assessment. To provide staff time for to pull historical context of other forestry related cases approved or denied in Emmet County. And for the applicant to include a berm on the north and west unforested portions of the property with an approximate height of 6 to 8 feet with trees on top.
Can I make a suggestion on that all You have north and west,
Uh-huh.
neighbors to the east. Neighbors to the south side of the driveway. The stills are on the south side. Just a thought.
That would be,
Which you can deliberate later.
We're talking about right there and there. My thing was like
Well,
the
their
trees.
neighbors, they're kind of,
That's the right.
they're right over here, from northeast, right?
So I'm saying the other road
And
would be here and here.
stills are back over here. Driveway.
Okay.
Let's just, if you're
Yeah.
gonna screen it,
I think also, provide some screening. How to describe this? To the, east of the easternmost snow storage location. It's kind of that gap. You understand what I'm saying?
Yep.
I think at that location, probably shrubs or a fence would be fine, but just that kind of pocket. Clear as mud, Monica? Anything else? Alright, that's my motion.
any discussion on the motion? Roll call, Monica, please.
Sure. Hinterman,
Yes to postpone.
Biddick,
Yes.
Alexander,
No.
Bates,
Yes.
Eby,
Yes.
Neal,
Yes.
Herzig,
Yeah.
Willcome,
No.
Kierman.
No. Okay. Move on to the next, order of business. Thank you, everyone. Public comment. Tony, you can't leave yet. He's putting his coat on. Anybody got public comment this evening? Yes, sir.
Yes, sir. Name's Robert Still, and I happen to own the 9.5 acres south of his property. You mentioned putting a barrier up in the east and west and north side. How about the south side?
That's what I mentioned, south to your
That-
driveways. Yeah, I think he noted that.
I did.
Yes, sir.
Okay,
Thank you.
thank you.
Anything else, sir? Anybody else public comment? Okay, other business? Master
Okay.
plan.
You guys are still awake with me.
Yep.
Master plan, just a couple of, quick updates first. Survey number 2 is still open. It closes on February 28th. We have over 1,200 responses received, so that's excellent. I put flyers at the entrance. Our, engagement committee is working very hard. Thanks, Nate and Jackie Hall have been, working quite a bit. Jennifer Neal, Scott Herseg, and, yeah, we continue to really work hard at getting that out.
I've seen it organically show up on my Facebook feed, just people sharing it, which has been cool. Not from the county, but just other concerned citizens. So I think that's a good sign.
Great, great. So, intended for tonight's agenda was going to be review of draft chapters 1 and 2. They were included, they were sent to the planning commission for preliminary review. We did get, some comments back from Jennifer Neal and Julie Hinterman on that. Those were, incorporated, and if they were, real specific, I guess, kind of administrative edits, we just took care of those. But then there's some more items that we noted. I don't know if you wanna try to look at those. Does anyone have any feedback, on the drafts? They went in your packet supplement. We can we can hold off on that. I think maybe we're ready to move on. Chapters 3 and 4, we would put in the March packet, and, if everyone's okay with it, we'll just discuss chapters 1 and 2 next month too, if there's anything more to cover there. I want to just distribute around, last month you received the annual report. It's the 2024 and 25 annual report. What I am distributing around is operating income and expense. This was updated because after year end, Tammy got better numbers, and I wanted to update that one page that's already existing in the report. So, I didn't put that on your desk because you already had too many things, but that is coming around. We distributed this to you last month. If you have any comments or concerns, it can be edited. If you're comfortable with it, then we can just have a motion to forward this to the Board of Commissioners to fulfill the requirement of reporting annually to the legislative body.
I think we can forward to the commissioners.
Motion forward?
Yeah, motion to forward to the commissioners.
Support. Motion support. Discussion. All those in favor signify by aye.
Aye.
Those opposed, same sign.
Okay, next,
Thank you.
site plans reviewed administratively. It's actually, the address is incorrect. It's 1922, not 2022, Harbor Petoskey Road, and I'm just bringing this up to let you know that this is actually on hold. There's some more considerations to look at, so this might be on the agenda next month, but it's on this agenda, so I felt I should at least give you that update.
And that's right on.
This is this is Be May Bags,
Yeah,
the
that's
parking lot there. Just they're exploring the idea of having some food trucks in that parking lot.
I think we had a temp there, right? Wasn't there
There-
permit a while,
There was
couple
trying
years
some
ago?
interesting things in that lot.
A few years,
Yeah.
they granted temp, was it
Yeah.
around 2020 there?
Originally, they were gonna do like a bunch of storefronts along, where Thomas and Milliken filled in, was potentially gonna be like.
Yeah, that was like
Exactly.
a commerce.
Yeah,
store,
yeah.
I think.
Yeah.
That was nice, but not commerce, but yeah.
Okay,
Commercial
we
plans.
have the proposed text amendment that we have been talking about for commercial storage uses. Just reporting back that the Board of Commissioners adopted that resolution that you all reviewed and discussed, and determined that that pause would be in effect until your recommended September 1st date. The resolution and other materials that the Planning Commission already kind of looked at on a preliminary basis, a little bit of analysis, that was forwarded to all the townships for which the county does zoning, and asked for their preliminary review and comment. We felt like that would be a good place to start, rather than get them involved after we're too far down the road. So they got a copy of the resolution, those materials, and they also got a listing of the, I guess what we know right now of self-storage uses in the county, and asked if they are aware of any others that they don't see on the list to add to it, because that's also information that we're trying to bring back for review and study, is just the number that we already have. So that's where we are with that. That, we requested to have all that information back by March 26th, and the Planning Commission will review that on the that feedback on the April 9th agenda. We might have additional analysis or more information to provide next month, but that's kind of where that is right now. Any questions on that? Planning Commission bylaws, this is just here to note that they were included in your packet. They were updated in January, and this is part of the annual review that we do with the bylaws. And then just noting the communications that we received, wanna remind you that the Village of Pellston Master Plan Amendment A on that infrastructure expansion, that was included in your packet supplement. It was sent to you via email, but there is a hard copy of that on your desk. And the only other item is comments from commissioners, if anybody dares.
Got anything?
I'll say something. That master plan status got kind of rushed through, just a matter of seconds here. But I wanna get something in there, what I consider to be the most important part of the master plan for Emmet County in the future, and that's to promote business. Because if you don't have business in Emmet County, you don't have jobs, and without good jobs, population cannot purchase housing, good health insurance, good dependable transportation, or secondary education. I think Emmet County's getting kind of a bad name in the last few years for being anti-business, and I would like to change that. I would like to promote business in Emmet County.
Okay. Laurel, take that. Or there's something in there.
Yeah, we don't have to talk about the chapters, but I thought it was really interesting to see where the growth is and isn't happening within Emmet County, and I thought those breakdowns were really a lot of good insight for where things are moving and not.
I can't believe our load was cut over.
Our load?
Yeah, our cases.
Oh, yeah.
46 to 19.
Yeah. But as pointed out, when we looked at that annual report in the first place, that was a testament to all of the text amending and ordinance updating, slogging through that, which allowed more of those things to be taken care of administratively before it got here. So I think that's a case of a lot of time invested in the front end is saving, you know, a little bit of time the whole rest of the way. That'll be the gift that keeps on giving.
We also noted that quite a tremendous amount of staff time and planning commissioner time was devoted to the master plan update. All the reviews of those chapters, thanks again to, you know, anyone who's provided any feedback. What we're looking for is, you know, comment and input on how we want to make some changes. When we get into the implementation stages, that'll be even more important. So we kind of move from theory and background studies into actual, you know, actionable steps that we can take. But anyhow, that was a big part of the last couple of years, really, is working on the master plan. And several of the cases that we had in the past year were on the agenda multiple times. So that's something else to keep in mind.
There was, I don't know what'll be in chapters 3 and 4, like I haven't read those yet, but there was a great point made at the Bear Creek Township Planning Commission meeting, I think it was, about like trying to capture an infrastructure map, like where it exists in the county, and it always comes up like, oh, does it or doesn't it have sewer and things, and I thought that was a really good idea to capture, because I don't think any lay person walking around, you know, is aware of what's beneath them or above them in that regard. Yeah.
Those maps were included in the October open houses. The maps that we shared and had out, and asked for citizens, participants to put stickies on where they think development should occur. And we very deliberately, you know, intentionally added that infrastructure, because of course that's a factor in where future growth can happen and where businesses can locate and so on. But yeah, that is a good bit of insight, yeah.
Anything else? I'd like to address, Mr. Stella got this letter. Thank you for your service. Apologies to you, so thank you, sir.
Thank you.
Anybody else got anything? Okay, we stand adjourned.